sir, for this.
All order 41 here.
May I have your lordship's kind leave?
Order 41.
Yes.
Okay.
Lord,
Applications. No, extension of interim order.
Milord, Milord, I put a leave, Milord, file without, Milord, Tandon copies and Milord, degree copy of the lower court, trial of Milord, I have missing, Milord. But both the court, Milord, I lost, Milord. Kindly allow me to file the application.
When the order was passed by the appellate court.
Milord, passed, Milord, on 8th of May 2023. No, within
8th May.
No, within time, Milord, but 16th the last time, Milord, 83 days for appellate court.
No.
No, only your judgment, judgment I have been. Only the my lord.
Go and file.
My lord, may I be?
Degree is not required. You go and file.
No, the appeal court order is not with me. The judgment the trial court in the suit. Suit judgment.
No leave is required. You go file defective. We will consider at the time. No.
My file is saying, Milord.
Give a photocopy. We'll consider it. Give.
My lord, may I be permitted to mention, my lord, on matter, my lord?
My lord, file is cannot allow me, Milord.
Please go. If they do not allow us, come. We'll see to it. You go.
May I be
now central filing section? Yes.
May I be permitted to mention on matter, my lord? This matter, my lord, pertains to an order and decree passed by my lord, the city civil court.
I don't have a determination. Why you are coming before me?
No, that is the reason, my lord. I want your lordship to release this matter for my lordship.
Have you seen the determination?
Yes.
So why the release is required?
No, but this is
Admission of appeals under order 41 rule 11 of the court, including the applications connected therewith, excluding the matters arising out of city civil court.
That is exactly, my lord, why I am
That's
bothering
all.
your lordship.
First appeal, first miscellaneous appeal, and applications connected thereto, excluding the matter
Yes,
arising.
erroneously, my lord, this matter is appearing before lordship.
Which item? Which item?
My lord, on the last 6th of October, this matter has been taken up. None had appeared. It was not indicated to your lordship that this matter pertains to
Which
city.
item?
And today, my lord, this matter is not appearing because your
appearing.
lordship
Then
has directed this matter
No.
to after Puja vacation.
Go
So, my
and
lord, in
mention.
any event, my lord, your
Go and mention the matter. We don't know.
my
Anyhow.
lord.
my lord, sorry for disturbing your lordship, my lord. I have mentioned this.
Senior.
Sorry.
May I have lordship's leave to mention item T 255 in the contempt application appearing for the first time. I tell you, lordship's order was payment of pension to a person.
Anyhow, come tomorrow. We are taking up applications tomorrow.
Milord,
And
this was
next
for
week we will be taking up whole day. Don't worry.
this contempt applications.
All applications in order 41. Don't worry.
May I have my lord's kind leave to mention the second appeal, my lord, for admission and for interim relief. The judgment of reversal passed by the learned Alipur court. Order 7, rule 11, we succeeded. All interim orders stood vacated. That's been reversed. My lord, the urgency is the interim order.
No, reverse means the allowed.
Allowed.
Sorry, I mean appeal allowed, dismiss.
Appeal allowed, suit has been restored and the interim order is restored.
Now tell me whether it is an appellable order. Come ready.
I will check.
Check, come ready.
May I be permitted to mention, my lord?
Check and come ready.
I am not very sure. I'll read and come back.
Please read. One judgment of Justice Bhaskar Bhattacharya. Read that. There is a dissenting judgment again, I am telling.
I will keep coming back.
No,
Let me read
please.
those 2 cases, then I will come.
Read.
Lordship, may I be permitted to mention, my lord? This is pertains to item number 250, my lord. It is appearing as under the contempt application heading, my lord. My lord, have a very long list of applications, my lord.
Don't
Generally,
worry. Whole week, next week, we will be taking up. Don't worry. First half application, second half order 41. Don't worry.
my lord, it is item 250, my
Let
lord.
us
Will it
don't
be-
underestimate the pace of the court.
Lord, I'm not.
Come.
My lord,
Let us
may
see. Let
I
us see.
give the mention?
Not necessary.
My lord, may I permitted to mention for application, my lord?
Simply give. Don't mention.
Grateful, my lord.
Simple give.
My lord, client is giving non-prosecution letter, but my lord, there is fact I want to clear. My lord, on my lord, that matter was dismissed for default. My lord, earlier, two applications have been filed, one restoration
আজকে 12 না 13
My client has given the letter not to proceed with the matter, but there is a fact where I want to clear. And earlier the matter was dismissed for default on 23rd of April 2022. The application has been filed for restoration. There's application number 2, 3 is section 5 application. I pray that may be restored and withdrawn.
No. আমার এসএ ক্যান নাম্বার সাচেন্সা যাহা হাইকোর্টের বিচারের পর্যায়ে রইয়াছে তারা আমার আর চালাতে চাই না এভরিথিং দে ডু নট ওয়ান্ট টু নেভার সেড রেস্টোর্ড এন্ড দেন all can 1 can 2 can 3 all the she has or the client has said I do not want to proceed.
Malware 2 application, restoration application.
No,
As-
that is all.
My
What is
lord,
that application? These are
because
can
they-
1, can 2 and can 3.
only can 1 as essay has to dismiss for default. 2 and 3 2 is restoration application.
Correct. But your client has indicated that she does not want to proceed with that application also.
My lord, the mistake
যে আমার মামলাটি যাহার নম্বর SA 61 of 21 can 1 of 2020 can 2 of 2022 can এবং can 3 of 2022 যাহা হাইকোর্টে বিচারের পর্যায়ে রইয়াছে তাহা আমরা আর চালাতে চাই না. What does it mean? That all these they do not want to proceed. Then if you dispose of these restored and then non-prosecution, it is against the mandate of your client.
kindly take up next week. I shall take a
No,
letter.
no, we will dismiss it. We'll record that.
My lord.
Hey. Who are the
Dismiss
appellants?
that not press, my lord.
Yudhishthir Ghosh, Nokul Chandra,
Nokul Chandra Ghosh.
আচ্ছা আমি বুঝতে পারছি এটি নকুল ঘোষ চন্দ্র চন্দ্র নেই আচ্ছা এখানে ফার্স্ট টাইটেলে উনি করে দিয়েছেন নকুল চান্দ্রা ঘোষ চান্দ্রা দিয়েছি হ্যাঁ এখন কি করব Have you noticed the problem? Appellant number 2, how you have described, it's not Chandra. Instead of N, it is M.
My lord.
And in the Vakalatnama, the gentleman has signed as Nokul Ghosh, not Chandra.
My lord.
What are you doing? Huh? Correct. Put in the alias. Alias Nokul Chandra Ghosh, alias Nokul Ghosh. চন্দ্র সেটাই বলছি হ্যাঁ তাই করতে হবে do one thing
My lord, in
We
the
are-
transfer date.
sir you have inherited the asset you must inherit the liability
My
both
my lord. Yes,
can't
yes,
can't say I will only inherit asset I will not inherit liability
my lord. I follow.
do one thing only one way of getting rid of it is we are guarantee you leave to put a alias because the Chandra has been wrongly typed here. So just put in alias Nokul Chandra Ghosh, alias Nokul Ghosh,
My lord.
and then we are allowing everything.
My lord, may I do here and now, my lord?
Here and now,
My lord, you will
Leave
pass the order. I
leave is granted to the advocate at record of the petitioner to put in to correct the name of the appellant number 2 by putting an L in name appellant number 2 here and now. The advocate and record of the petitioner mentions the matter before us on instruction received in writing by him that his clients do not intend to proceed with the instant matter. The written instruction filed today reveals that the appellants do not intend to proceed with SA 61 of 2021, Can 1 of 2020, Can 2 of 2022, and Can 3 of 2022. কি লিখেছো Can 1 কি লিখেছো of Can 1 of in view of the above, in view of the above, the SA 61 of 2021 is dismissed for non-prosecution. Accordingly, the connected applications as mentioned there herein above are also dismissed for non-prosecutions. Let the written instruction received by the advocate and record of the appellant be kept on record.
Earlier advocate is no more. This is fresh power I have filed. May I do it, my lord, because I am the present advocate.
Have you filed a wakalatnama?
Yes, yes.
Filing number?
Filing number. But this is the computer. Receiving.
Which one? Judicial? No, wakalatnama?
My first one. First page.
No, wakalatnama.
It is first page of the that is. First
No,
page.
first page is petitioner and
No,
advocate.
not that. Before that. Before.
The present advocate and record files wakalatnama after obtaining a no objection from the erstwhile advocate on 28/8/2023. Office is directed to tag the wakalatnama with the instant file.
I'm grateful to you, Lord.
Then we ordered it. Next, put a file ta diye dao. Akkuri korte. Give alias.
My lord, I'm fine.
High dismiss for default applications pending ছিল সেই জন্য সব হয়ে গেছে।
My lord, this matter I am praying for short passover, my lord.
If you pray for Passover, then it will be Passover till vacation. His choice is yours.
Oh, my lord.
Sorry, my lord.
What is why we directed application? We wanted to dispose of here and now.
Lord, I filed an application for leave to appeal. My lord, what's happened, my lord?
Oh. Yes.
My lord, one Narendranath Pal, my lord, was the original owner of 21 decimal of land. And my lord, he made settlement through two deed of settlements in favor of his sons. One settlement deed for 5 sons and another settlement deed for 2 sons.
So he had 7 sons.
7 sons. And my lord, in 1986, the settlement deed was executed in favor of 2 sons, measuring about 6 decimal of land. 6 decimal of land.
What? In 1986.
86.
Yes.
The settlement deed was executed and registered
Correct.
in favor of 2 sons.
That I know. 2 sons and 5 sons.
5 sons.
Separately.
My lord.
Yes, then
And my lord, the deed which executed in favor of two sons, one son was bachelor. And during the lifetime of Narendranath,
Unmarried.
my lord,
See, unmarried.
unmarried. And my lord, the unmarried son died. And after demise of unmarried son, my lord, the property again executed by Narendranath Pal in favor of his another grandson.
How can he?
Yes.
How can he?
And that's why, my lord, the mother of the unmarried son, being the legal heir, filed a suit. She was the plaintiff in the suit. And in the suit, she claimed half share which belongs to her unmarried son. And my lord, the suit decreed in favor of the mother of the unmarried son. And after passing the decree, the mother executed gift deed in favor of this appellant.
Who is the appellant?
Appellant is the grandson.
In whose favor the grandfather gave it?
My lord, grandfather executed in favor of another grandson.
Another grandsons means the son of a predeceased son. Sorry, when another grandson means son of the
Another five son of the five sons.
Oh. And now this time son of the second son here.
My lord. No,
Then another five.
another five.
Yes.
And but the another son in whose favor the
Two sons were there. So one
Yes.
who was surviving.
surviving, my lord, said Narendranath Pal again executed the gift deed in favor of the surviving son.
In respect of a share of her deceased son.
Deceased son.
Before the mother or after the mother? Before the mother settled or give a gift deed or after the
No,
mother?
Before.
Before.
And well, that's why the mother filed the suit. And suit,
And that deed was declared to be void.
no, my lord.
No?
That had not been challenged in the suit. Mother filed the suit for declaration and for permanent injunction. And my lord, the court of the first instance, my lord, decreed in favor of the mother. And after getting the decree, my lord, after expiry of the limitation period to prefer the appeal, the mother executed another gift deed in favor of this appellant. And my lord, the surviving son filed the prefer an appeal after expiry of the limitation period. And my lord, the appellate court reversed the decree.
On what ground?
On ground, my lord, the court of the first instance holds that the settlement deed, the nature of the settlement deed is nothing but the gift deed. Gift deed. And have the vested right in favor of the legal heirs of the deceased son. But the appellate court said, my lord,
Yes. So mother is a heir.
heir. But the appellate court said no. Because the deed of settlement was executed in favor of the unmarried son. When the unmarried son died, the property revert back to the original settler.
Then what it is held, the settlement is not a gift.
It's not a gift.
It is a will.
Will.
So what to do?
And prior to passing the judgment and decree in the appeal court,
Can you show me the settlement deed?
yes,
Sure.
I annexed it with my
This
stay application, my lord.
yes, 2 sons. Sure.
My lord, page 26 of my stay application.
Stay application is can 1,
Can 2.
can 2. Can 1 is leave.
Leave to appeal.
Yes. Page
Page 26, my lord.
26. এই পড়ুন আমার তো I am unable to. I can't read.
May I read, my lord?
Such a bad handwriting. I can't read.
My lord, may I read, my lord?
Why don't you get it typed?
Sorry, Milord. Milord, settlement Patro Grohita, Sri Joydev Pal and Sri Ashok Pal. Joydev Pal is the unmarried son.
And settlement Patro Data, Narendra
Narendranath Pal.
Pal. Yes.
My lord, kindly come to next page. Page 28, my lord. It starts from the last two lines from of page 27, my lord. পূর্বক অন্যের বিনা সংস্রবে নির্বিবাদে খাসে দখলিকার আছি। আমার 7 পুত্র 1 পত্নী বর্তমান। আমার 7 পুত্রের নাম যথাক্রমে পেজ 28 তপন পাল, জয়দেব পাল, অশোক পাল, বাসুদেব পাল, সাচ এন্ড সাচ মিলর। আমার পত্নীর নাম সুশীলা বালা পাল। আমার পুত্রগণ আমাকে ভক্তি শ্রদ্ধা করে আমি ও পুত্রগণকে অতিশয় স্নেহ করি। আমার দেহান্তে উক্ত বাস্তুভিটা লইয়া পুত্রগণের মধ্যে অশান্তি না হয় এই জন্য আমি উক্ত 21 শতক ভিটা আমিন দ্বারা চিহ্নিত করিয়া এ বি মার্কা প্লটে বিভক্ত করিয়া এ মার্কা প্লটে লাল রং দ্বারা পরিবেষ্টিত 15 শতক বাস্তুভিটা জমি জমামায় মাটির দেওয়াল টালির ছাউনি যুক্ত ঘর একখানা আর এটা মায় তদুপরিস্থিত বৃক্ষ আওলতাদি সহ আমার পুত্র তপন পাল, বাসুদেব পাল, কৃষ্ণ পাল, কার্তিক পাল, গণেশ পালের নাম বরাবর বিভিন্ন দলিল দ্বারা সেটেলমেন্ট করিয়া দিয়াছি। বি মার্কা প্লটে সবুজ রং দ্বারা পরিবেষ্টিত 6 শতক বাস্তুভিটা মায় বেড়া ঘর দ্বারা বেড়া ঘেরা টালির ছাউনি ঘর একখানা মায় তদুপরিস্থিত বৃক্ষ আওলতাদি সহ সেটেলমেন্ট পত্র গ্রহীতা জয়দেব পাল, অশোক পাল নাম বরাবর অত্র দলিল দ্বারা সেটেলমেন্ট করিয়া দিলাম। সেটেলমেন্ট গ্রহীতাগণ আমার জীবদ্দশায় নিম্ন তফসিল বর্ণিত সম্পত্তি কোন প্রকার হস্তান্তর দায়বদ্ধ না করিয়া না করিয়া অদ্য হইতে আমার দখলে দখলিকার হইয়া মালিক সরকারে খেরাজ আদায়ে এবং মিউনিসিপ্যালিটি অফিসে ট্যাক্স সরবরাহ করিয়া পুত্র পুত্রাদি ওয়ারিসান স্থলাবর্তীগণ ক্রমে উক্ত সেটেলমেন্ট কৃত অত্র সহ নকশায় বি মার্কা প্লটের জমিতে গৃহাদি ইমারত নির্মাণ পূর্বক বসবাস দ্বারা ভোগ দখল করিতে থাকেন। ইহাতে প্রকাশ থাকে যে অত্র দলিলের তফসিলভুক্ত সম্পত্তি মায় বেড়া ঘেরা টালির ছাউনি ঘর একখানা আছে। উক্ত ঘরে আমার জীবদ্দশা পর্যন্ত বসবাস করিব। তাহাতে সেটেলমেন্ট পত্র গ্রহীতা দ্বয়ের কোনো ওজর আপত্তি থাকিবে না। আমার দেহান্তে নিম্ন তফসিল বর্ণিত সম্পত্তি মায় গৃহ সহ সেটেলমেন্ট পত্র গ্রহীতা আগণ দখলে কায়েম দখলিকার হইয়া পুত্র পুত্রাদি ওয়ারিসান ও স্থলাভিষিক্ত গণ ক্রমে উক্ত কার্যের দ্বারা এবং দান বিক্রয় বন্ধক ও সর্বপ্রকার হস্তান্তর দ্বারা নিবিড় সত্ত্বে ভোগ দখল করিবে। তাহাতে আমার অন্য কোনো ওয়ারিসানগণ কোন প্রকার দাবি দেওয়া থাকিবে না, করিলেও তাহা সর্ব আদালতে অগ্রাহ্য ও না মঞ্জুর হইবে। নিম্ন তফসিল বর্ণিত সম্পত্তি আমি ইতিপূর্বে কোন প্রকার হস্তান্তর দান বিক্রয় বা বন্ধক দায়বদ্ধ করি নাই। সম্পূর্ণ নির্দায় ও নির্দোষ অবস্থায় এবং খাস দখল অবস্থায় আছে। নিম্ন তফসিল বর্ণিত সম্পত্তি আদির আনুমানিক মূল্য 2000 টাকা। After the next page, the schedule. Milord, the suit was filed in respect of only 3 decimal of land. 2 brothers, Milord, 3 decimal and 3 decimal. And this deed of settlement, Milord, after executing the execution of this.
What is the value of the property? He says 20,000.
2000 টাকা। 2000 টাকা হইবে। Milord, page 29, last line. 2000 টাকা।
Which year? 86.
86, my lord. Yes, sir.
এটাই তো এটা প্ল্যান করে করেছে আপনার স্কুল বলেছে প্রবলেমটা হচ্ছে গিফট হলে কিন্তু it will immediately go there. রিভার্ট করে রাইটটা কিন্তু তারপর রাইটটা আসে ক্লিক করছি মানে মাদার তারপরে যেহেতু আমার হাজব্যান্ড ছিল হাজব্যান্ড উনি যখন যদি গিফট করে থাকে so it was a joint gift in the name of two sons. If one son then I being ছেলে কিন্তু এই জায়গাটা আমি শেয়ার করি she's correct class one brothers are that's something কিন্তু দেখা যাচ্ছে যে এই গ্র্যান্ডমাদার এক্সিকিউট করার আগে যে মুহূর্তে ওই ছেলেটা মারা যাচ্ছে ওরা কিন্তু জীবিত ছিল নরেন্দ্র তখন একটা ডিড অফ গিফট করে অন্য একজন তাকে দিচ্ছে। এখন যেটা হচ্ছে যে whether the father নরেন্দ্র retain the rights to do so. If it is a gift, then he divested. If it is a gift, then he তখন mother asked him, at the time of death, the father was and he was the executor, but he can execute it. So that deed will that is a very short question. Interpretation of justice. So only interpretation, whether it is a will or it is a gift. Is a gift. It's a gift. That's only. যদি আমরা গিফট বলি তখন ওই যে যদি গিফট বলি পড়ে সেই জন্য বললাম আমি পড়তে পারলাম না আপনার এই জন্য আমি আপনার কি কেন anything which is any right is created in future and after my death then it will always constitute a prospective gift হয় না
তো ধ্যানতে বলা আছে টেক ইফেক্ট আফটার দ্য ডেথ অফ দি
correct যদি তাই হয় তখন it cannot be a gift যদি gift না হয় তখন তো he retain he remain as owner so long as he alive he can execute একদম সিম্পল পয়েন্ট আর কিছু
ক্রিটিক্যাল কোশ্চেন
critical question আমরা ইন্টারপ্রিটেশন জাস্ট only কিছু করা দরকার
ইন্টারপ্রিটেশন মানে
the grandmother is not challenging
The deed.
grandmother is not challenging the decree
No,
she's alive
no, my lord, died.
anybody was substituted
My lord, the other legal heirs of the grandmother substituted, but I have not been implicated.
no you will not
Right.
will not get it your father or uncles or something they were there
They are in
your father is alive
my lord,
yes. So he was substituted
my lord.
he is not challenging
No, my lord. My lord, the appellate court, my lord, the
Sir, very simple question.
My-
Point is very simple. The point is, what is the nature of this deed of settlement?
My-
If it is a gift deed, then the grandfather Narendra Babu did not have any right to divest again. If it is a will, then even one of the son died, Narendra Babu remained the owner and he can divest the.
My lord, this is my humble submission.
No, this is what is the only point. What humble submission?
Yes, my lord,
What
the
is the-
first appellate court did not hold this, that the nature of the deed is will.
No, that has to be a will. That is our prima facie opinion.
My lord, my humble,
আমার দেহবাসনের পর they will become owner, enjoy all the right. What does it mean?
my lord, in my humble submission, my lord, it is the
In a-
partition deed like gift deed, my lord. Because, my lord,
Correct. If you are correct, then the gift would take place immediately on the date of an execution. There cannot be creation of a future right in future. The moment the right is created in future, then it cannot be regarded as a gift. On section 121 of the Transfer of Property Act, please read.
yes, my lord, this is the contingent interest, my lord.
No.
My lord, my
Contingent
submission
means
is
what?
vested interest.
No.
Section 19, my lord, I
know
am banking
19 and
upon. my lord.
20 both. But again, I'm saying 19 and 20 when? Contingent and vested?
My lord, kindly have a look into 19 first, my lord.
Please, there is one judgment of the Supreme Court on this score as well. What is the meaning of a vested interest and what is the meaning of the contingent interest? Dichotomy between the section 19 and 20 of the Transfer of Property Act. Look, first you'll have to look section 121 of the TP Act. What it
What-
says.
My lord, 121 exchange of money.
No, sorry, 122 is there. What?
Yes, my lord, gift.
Yes, please, sorry, my section, my remembrance is some
My-
122, please.
My lord,
read.
gift is the transfer of certain existing movable or immovable property made voluntarily and without consideration by one person called the donor to another, called the donee, and accepted by or on behalf of the donee. This is 122, my lord.
What does it mean? It's a kind of a,
My lord,
it
this
is a
the
kind of
gift
a,
without consideration. And the right,
the gift plus first sentence of that 122.
gift
What-
is the transfer of certain.
Yes, now question is
existing-
transfer. What do you mean by a word transfer? Forget about it. It is a transfer. How the transfer takes effect?
My lord, section 5. Transfer of property means an act by which a living person conveys property.
Now question is conveys property. Conveyance, then you'll have to, what is the meaning of the word conveys? Divestation of his right, title and interest immediately.
My lord.
Now the question is again, there are galore, the decision galore on that point, that the deed of settlement is always considered to be very complex. Because the nomenclature of the deed is not a determinant factor. It is an intention which has to be gathered from the language used in a document. And if the language shows that he divested his title immediately upon an acceptance, then in that event, it will be always regarded as a gift or a permanent settlement of the property. But if he retained his right till his lifetime, and thereafter that right goes to a respective persons, then it will always be regarded as a will. And very simple, if it is a will, then on the death of the son, since he remained a owner till his lifetime, if he executed a deed of gift, then that deed of gift cannot be challenged. But if by settlement he has gifted the property, then he is denuded of all his right in respect of the property. On the death of this son, the mother being his mother, being the class 1 heir,
My lord.
she will inherit his share. She will be regarded as a owner in that regard. If she executes anything, then that would be regarded as a valid and correct in eye of law. And the father's deed will not be considered because he has no alienating right. Here the question lies on the interpretation. What the deed of settlement is saying. What was the intention of Narendra Babu? Was
Yes,
it a deed of gift or was it a will? He is saying that so long I am alive, I will enjoy the whole of the property. And after my death, it will go to these two, my sons, who will enjoy eternally, posterity to posterity, having right to sell, having right to develop, having right to make construction, whatever. If that being the position, then what? Now you are talking about section 19 and
19.
20. Please consider this and consider the judgment of the Supreme Court, where the Supreme Court has said that what is the dichotomy between 19 and 20? What could be regarded as a vested right and what could be regarded as a contingent right?
Yes. Lord,
Read.
your lordship was talking about Lachman versus Baldao case.
I am talking since 1923 Calcutta.
Boi nai.
Yes.
Sorry, sorry.
EIR 1923 Calcutta, from there I am talking about. And
Then-
2004 or 5 Supreme Court judgment is there on this vested right and the contingent right. Very aptly and very elaborately it is making a elaboration.
Milord, may I we come back, Milord, after going through that judgment, Milord? Because
Kindly read. Where on a transfer of property come to the vested interest, section 19.
Milord, section 21,
No, 19, please come.
19.
It says where on a transfer of property, an interest there is created in favor of a person without specifying the time, kindly visualize, when it is to take effect, or in terms specifying that it is to take effect forthwith, or on the happening of an event which must happen. Such interest is vested unless, this is very important, a contrary intention appears from the terms of the transfer. A vested interest is not defeated by a death of a transferee.
Yes.
Transferee, not transferor. Transferee. Before he obtains possession. Explanation. An intention that an interest shall not be vested is not to be inferred merely from a provision whereby the enjoyment thereof is postponed, or where the prior interest in the said property is given or reserved to some other persons, or whereby income arising from the property is directed to be accumulated unless the time of enjoyment arrives, or from a provision that if a particular event shall happen, the interest shall pass to another person. How it applies? Suppose in case of a minor, take an example, that an interest is created in favor of a minor, and then saying that so long the minor attains majority, it would remain in this form. Whatever the income that would be generated will be accumulated. Nobody will utilize it. And after he attained the majority, it will go to him with the accumulated interest. This is called a vested interest. On the day itself, the divestition is manifest. Divestition is manifest. Again, there is a catchword which says that it must happen. The event, word is used
Yes.
that it must happen. Happening of an event which must happen. Normally,
It is certain.
everybody thinks that he will attain a majority by passage. But that is also very dicey. Nobody knows the God's prerogative. Nobody knows the God's prerogative. This was taken care of in the second sentence. That a vested interest is not defeated by the death of a transferee. He was 15 years of old age. Interest is immediately created in him. He will get it at 21. 6 years period. God forbid, if something happens to him at the age of 18 or 19. What will happen? Because must happen, the word is must happen. That has not happened. That's why the legislature says no. This vested right will not be, because normally and ordinarily everybody thinks that he will live long and he will attain a majority. So that's why I say the vested interest is not defeated by the death of the transferee, means in whose favor it is done. That is called a vested interest. Come to the contingent interest in 21.
20.
It says where on a transfer of property, an interest there is created in favor of a person to take effect only on the happening of a specified uncertain event. Kindly, uncertain event. There, it was a certain event. Certainty was there. Here, it is the uncertain event. Or, if a specified uncertain event shall not happen, such person thereby acquires a contingent interest in the property, means on the happening of that uncertain event, he will. Unless that happens, he will not. Such interest becomes a vested interest in the former case, means on a happening of the event. On the happening of the event, in the latter, when the happening becomes impossible. When you talk about all these things, then you should know what is there. Gift does not contemplate the future transfer. Because one of the condition under 122 is acceptance by the donee. Can he accept in future?
No, after demise of the settler.
No, he cannot, even later on. He has to immediately effect. Look the language of 122, that is what it says. Gift is a transfer of a certain existing movable or immovable property made voluntarily and without consideration by one person called the donor and to another called the donor, and the word is in a past tense, accepted by or on behalf of the donee. So donee has to accept what you have given it to me, I embraced it. Can it be a vested or a contingent? It's an immediate right which has got. Cannot be done in a future. Otherwise, the word is accepted word would not have come in past tense. It should be and accept by the donee. Why accepted?
Lord, in the instant case, my lord, after execution of the deed of settlement, the possession already handed over to the settlee. And
The language
yes,
is
and the
different.
construction was made over that property.
No, that is a different path. The Hon'ble never objected to it. That is not a case.
And we'll have,
Hon'ble says, I will remain so long I am alive. You will acquire right only on my death.
yeah. But my lord, the deed of settlement says, my lord, the moment he executed this deed of settlement, he had handed over the possession, but the enjoyment is not taken over by the.
He says, Amar Dokhol shall be regarded as your Dokhol. That's all.
Only in respect of one room. Only in respect of one room.
What about the
Which the
others?
deed says, my lord.
Important to- I can't read it. My brother is in a better position to read that.
আমার দেহান্তে নিম্ন তফসিল বর্ণিত সম্পত্তি
একটু জোরে বলেন না ওকে।
আমার দেহান্তে নিম্ন তফসিল বর্ণিত সম্পত্তি
My lord,
My-
page, my lord,
পেজ নাম্বার 29
20.
what it my গৃহসহ সেটেলমেন্ট পত্র গ্রহীতাগণ দখল কায়েম দখলিকার হইয়া পুত্র পৌত্রাদি ওয়ারিশগণ ও
What does it mean?
স্থলাভিষিক্তগণ
আমার দেহান্তে
দেহান্তে আমার গ্রহীতাগণ দখল কায়েম দখলিকার হইয়া পুত্র পৌত্রাদি ওয়ারিশগণ ও স্থলাভিষিক্তগণ ক্রমে ক্রমে কার্যের দ্বারা এবং দান
Sorry, my lord, this is a fast paragraph, my lord. I did not find.
middle portion 29 page na middle portion
just bit below the middle portion.
second paragraph middle portion
Oh, এইখানে মিউনিসিপ্যালিটি অফিসে ট্যাক্স সরবরাহ হক দিয়া পুত্র পৌত্রাদি ওয়ারিশানগণ হোক সেটেলমেন্ট
My brother can read faster than you.
experienced, my lord. Very much experienced.
He practiced in a district courts,
My lord.
and from there he is elevated, so he knows better.
পত্র দলিলের তফসিলভুক্ত জমিতে ঘেরা ঘেরা টালির ছাউনিযুক্ত একখানা ঘর আছে উক্ত ঘরে আমার জীবদ্দশা পর্যন্ত বসবাস করিব তাহাতে সেটেলমেন্ট
জীবদ্দশা পর্যন্ত বসবাস করিব
হ্যাঁ।
only in respect of single room,
Read.
my lord.
তাহাতে সেটেলমেন্ট পত্র গ্রহীতা দ্বয়ের কোনো ওজোর আপত্তি থাকিবে না আমার দেহান্তে নিম্ন তফসিল বর্ণিত সম্পত্তি
নিম্ন তফসিল বর্ণিত সম্পত্তি
ও মাই
তফসিল বর্ণিত সম্পত্তি is the entire property. Remember,
মাই গৃহসহ সেটেলমেন্ট পত্র গ্রহীতাগণ দখল কায়েম দখলিকার হইয়া পুত্র পৌত্রাদি ওয়ারিশগণ ও স্থলাভিষিক্তগণ ক্রমে
it is not restricted to one room.
কার্যের দ্বারা এবং দান বিক্রয় বন্ধক ও সর্বপ্রকার হস্তান্তর দ্বারা
That is after his death.
নিবিড় সত্ত্বে ভোগ দখল করিবে
Then
তাহাতে আমার অন্য ওয়ারিশগণের
ওয়ারিশগণের কোনো আপত্তি থাকবে
কোনো
না।
প্রকার দাবি দেওয়া থাকিবে না
থাকবে।
ওইটা থাক অগ্রাহ্য হইবে
What does it mean, sir? Very simple. Nimno topsil sampatti means the entire property which is there in the deed.
Lord, after demise of the
Restricted.
yes,
Now that is the whole problem. I again say, if it is a will, future interests, not a gift, then this event did not happen. This event did not happen. What event should happen? The death of the donor.
yes,
Because he says, Amar Dihante. That is an happening of the event.
yes, my lord. This is my
It did not happen. The happening of the event is not the death of the donee. Happening of the event is the death of the donor,
yes,
which never happened. Then in that event, he wanted.
my lord. My lord, the nature of the deed, my lord, my humble submission is it is
Your humble submission
it
will
is
not do, but you have read
it
it.
is the partition, my lord, amongst the family members like gift.
No,
Mila-
partition, when it affect? When there are two concepts, please. The partition, when you talk about partition, there must be a pre-existing right.
Yes,
There must be a pre-existing right.
yes,
In this case, none of the son has a pre-existing right. Their right emanates from the deed because Norenbau was the exclusive owner. Partition deed is always executed in the nature of the pre-existing right and the division of their rights. Here, he was the sole owner.
yes, my lord.
He wanted to settle his property or give some of the property to some of the sons, some of the properties to another sons. So it is not a partition.
My lord, all the sons have the pre-existing right over the property of his
Oh.
father, my lord.
How? You are changing the entire concept of the civil law. Suppose the father who was the actual owner, he did not do anything. Upon his death, all his sons and the daughters, whatever, under class 1 years, they inherited and acquired the right. That becomes a pre-existing right, means right which was already created in them. And thereafter, if they chose to partition it, they can go and partition their share. So there was a pre-existing right before the deed of partition is executed. But here, Norin Babu was an exclusive owner. There was no other owner along with him. He wanted to settle. There are 2 or 3 modes of settlement he can do. One is he can create a gift in his lifetime. Second is he can sell the property to any of them. Third one is he can execute a will also, which will take effect after the death. Is there any 4th mode of transfer by him? Tell me.
The property, the nature of the deed, my humble submission is the property.
Question is only the nature of the deed. Now,
Yes.
trial court has said gift, appellate court has said will. My brother has also read it. We have also read the terms of the clause. We find that every right is being created in the after his death. And the will takes effect only after the death. Can it take effect during the lifetime of the testator or a testatrix? No.
But
And it is not a contingent right, not a vested right.
my submission is it
The
is vested right,
testator or
I will come back.
testatrix during his or her lifetime can revoke, can deal with the property, can do whatever they want
Yes, my lord.
during his lifetime.
If the nature of the deed is treated as will, my lord, then I have no right, my lord. But my humble submission is by this deed, my lord, the
You are
vested-
very humble person, but we will have to respect the law.
Yes, my lord, I will come back day after
No, no,
tomorrow
nothing.
after getting ready, my lord, the vested right and contingent right.
Not-
Kindly allow me this opportunity.
I am
at least, my
saying
lord.
you are simply buying time,
No, my lord. No, I will,
simply buying
I will
time.
get ready.
But
and I
after
will-
reading these two is very clear. In case of a gift, you can't say that. And
my
I
lord,
do not know.
if
You
your
want to
lordship
read the
allow me,
judgment,
then
you are.
I will,
Nothing.
at least I will come back with ready. My lord, my concept is by this deed, my lord, the
Sorry.
vested right is created in favor of the legal heirs of the deceased son. And my lord, therefore, Section 8 of the Succession Act is very much hit in this case. And therefore, the grandmother have the right to transfer this property after getting the decree from the court.
Mr. Mukherjee, there is one judgment which I have delivered with Justice Hiranmay Bhattacharya. Mr. Haradhan Banerjee argues the same line. And we have discussed what is a vested right and what is a contingent right.
Lordship.
And we have also discussed that a deed of settlement can be construed in what manner.
Right.
It can be at best will, it can be a gift, there is no difficulty. It all depends upon the intention of the maker of that document. Can you take that, find out that judgment which we delivered? I think that gives an answers to whatever his queries are, whatever his arguments are on the vested and contingent interests.
I think I also appeared in that matter, my lord.
Probably you appeared. Yes. Yes. What was that? Yes, you appeared against. Yes. Now I remember. Yes.
I was trying to defend
Correct
the
person
gift.
to tap. Correct
But I'll,
person to tap.
I
What is the
probably
name
have
of?
that judgment, my lord.
What is the name of that?
But I'll try to find out.
Yes. Correct person to tap. He was arguing. Mr. Haradhan Banerjee was arguing. I think in 2022.
Yes.
Ready হয়ে আসো। Yes, my lord, I will come back with ready, my lord. After going through this judgment, my lord.
Nothing.
Kindly, my lord, make it on Wednesday, my lord.
No, no, it's
Monday, my lord.
no,
Tomorrow, my lord. My lord, kindly allow me
he's
to.
giving you right now. Nowadays, I don't remember the name of the parties. I remember the
No, I am-
principles which I have decided. So that is what is when I was on that side of the room, I used to remember one name. Reason is obvious. Why should I remember the name? So Mukherjee, right from 1923 Calcutta, we decided the whole of the concept.
But I'm trying to find out.
Many
you know,
things
that-
was argued, Pardhanasi and all, everything was argued, I believe.
Lordship. But I'm trying to find out my lord's judgment and hearing.
I will.
Come tomorrow. You cited that judgment of the Supreme Court, vested interest and contingent interest on Mr. Banerjee.
I don't, Lord, readily remember, Lord, who had, Lord. But if I get, Lord, the judgment.
You
Lord,
argued the matter, you do not know what
I
point. you are-
remember, Lord, the ambit of the matter, but Lord, which of the judgment that I had cited, Lord, I don't remember.
You don't
But I'm
remember.
trying to, Lord, find out my written notes, Lord. I filed the written notes there.
Yes, next.
Lord, section 5, Lord, was rejected.
Rejected. Oh, sorry, by the trial court.
Appellate court. Appellate.
By the appeal court.
Oh, sorry, I mean appellate court. Certain dates, 232 days delay.
Yes, ma'am.
And trial court judgment was ex parte was passed on 21/4/2017.
Yes, ma'am. Lord, my application is at 94.
Contested degree or ex parte degree?
Ex parte degree.
But it is writing is contested degree.
Lord, there was
Counterclaim.
initially, my Lord,
They adduced evidence.
initially, my Lord, we
Lawyers
adduced
name appear in the degree.
initially, my Lord, we filed written statement, adduced
17
evidence.
under article
The
order
order
17.
Yes, order 17, and they also, my Lord, order 9, rule 13 also lies, but appeal is also preferred.
Execution case was dismissed.
Execution.
My Lord, the
Learned
execution
judge
was
is writing.
disposed of, they took possession.
Dismissed on full satisfaction. Can it be
Yes.
dismissed on full satisfaction? So instead of 232, it was 200 days.
Yes. But the reasons remain the same. There's no change in circumstance.
প্রপার্টিটা কাছে মোদি $6,00,000 ফাইল করে ডিগ্রিটা কোথায় গেল? ম্যাম, এটাই তো এটা হচ্ছে আমার মা।
Are you opposing? Answer one point.
Lordship.
Can the court take note of the event which happened pre-decree passed?
No, Lord,
I am
Not
asking you a
whilst-
very specific question. Answer me. Can a court take the conduct of a party at a pre-decree stage
Lord, the
for
court
the
has only
purpose
not
of condonation of delay in referring the appeal?
condonation of delay is not for the consideration of the period of delay, but not the court has only not observed
No,
about not the
It is the decision-making process which says that you were negligent, 4 witnesses were cited, you took time to cite a 5th witness, did not take, all negligence can be attributed.
those
to
are
the
all
conduct.
not narration of
These
facts
are
of
all,
the
these are
progress of
all
the
the
suit.
conduct pre-decree stage. Can it be taken into account? That's a very specific question. Yes or no?
Pre-degree, Lord, it cannot be taken into consideration, but here my answer is, Lord, that that is not the sole consideration by the judge. The judge has considered the explanation that has been given, and thereafter, Lord, the judge refused to accept the sufficient cause that was sought to be, Lord, shown in the application. If your Lordship sees their application, my Lord, for once, your Lordship will find that, Lord, what is their, Lord, explanation content there. They were not residing in the subject premises. They're not a tenant.
But then what for the suit was filed?
For, Lord, recovery of possession, Lord, on the ground, Lord,
So
that
their
they are the
possession was
trespassers.
admitted by you.
They were the
Their
trespassers.
possession was admitted by you. What is?
No
the
doubt
nature of-
about it. They also filed a counterclaim. The counterclaim was dismissed.
Right.
There's no appeal against the counterclaim. Now, my lord, the appeal is only directed against, my lord, the eviction decree. That is belated. Now, the learned judge says, upon, my lord, going through their, my lord, explanation, that, my lord, the sufficient cause has not been shown. Now, my lord, whether, my lord, the second appellate court can
There's
take a
no
different
question of
view.
appellate jurisdiction. If the finding is made by one court, then that is sacrosanct. No question of any appellate jurisdiction, nothing of that kind. Why the hierarchy of the courts are established under the constitution?
No, that is true, my lord, because, my lord, your lordship is there to correct, my lord, if there is any error. Now, the question is,
It's an
my lord, whether
appeal.
there is any
It's
error
a-
by the
it's
judge.
an appeal.
Yes.
It's an appeal. Kindly
Yes.
remember. Yes.
This is an appeal against, my lord, a very short point, that whether, my lord, the court was, my lord, right in refusing to condone the delay. So my submission before your lordship is, my lord, that the court was, my lord, not satisfied with the explanation shown.
Approach is what? Actor with judicial review. First appeal First appeal this is so distinguishable. It's actually for the ratio of the
Now kindly come to the, my lord, the explanation at page 96 of the application. Now, my lord, page 6, 95, paragraph 6. It is only on the 10th of November 2017 when the court bailiff visited the suit premises so as to obtain possession of the same, which had been under occupation of the appellant, pursuant to orders of title execution case number such and such, that the appellant came to know that the suit has been decreed in favor of the respondent. The
That is
appellant
a
states,
starting point of
starting point of the knowledge.
Correct.
The appellant states that at the relevant point of time, the appellant was not in her residence and was at Chandigarh,
Correct.
and was informed by the neighbors that what was taking place in the suit flat in Kolkata immediately after coming to know about the fact of taking possession of the suit property. The appellant, along with her daughter, rushed to Kolkata. After reaching Kolkata, the appellant contacted her erstwhile advocate so as to inquire about the matter. Thereafter, the appellant, upon meeting her erstwhile advocate, was informed that since the appellant did not contact her advocate for certain time, her advocate did not appear in the matter, and as such, the matter has been proceeded ex parte. The appellant states that the appellant was not acquainted of anyone else except her erstwhile advocate, who was aware of legal matters. As such, the appellant was clueless as to whom to approach for proper legal steps to be taken in the matter. It was only after the Jagadhatri Puja that the appellant, through one of her relatives, could contact one clerk engaged in Alipurpur. It is stated that thereafter the said clerk, after searching the records, could trace out that the ex parte decree was passed on 21st April 2017, in the third week of November 2017, and accordingly applied for a certified copy of the same on 17 November 2017 and received the same on 18 November 2017, next day. Thereafter, the appellant came in contact with her advocate through one of her relatives and briefed him about the matter. On 22nd November 2017, the advocate for the appellant, along with the appellant, held a conference with the senior advocate engaged in the matter, and it was decided that the appellant is required to prefer an appeal from the order in view. It is stated that thereafter the appellant gave instruction to her advocate for preparing the draft for appeal and the records of the suit, and it was inspected. It was stated that the draft of the appeal was prepared on 4th December, and it was forwarded to the petitioner on 5th November for going through the same. The appellant states that as such, there has been a delay of 191 days in filing the appeal, and appellant states and submits the delay in filing the appeal is not due to any intentional acts.
What more can be a sufficient cause?
Lord, she
If
was not there.
This is dismissed. I think no section 5 deserves to be allowed.
She was not here, my lord, in Kolkata. She was staying with the daughter. That is her admission.
Absolutely,
Yes.
sir. She has a daughter. She is a widow.
85-year-old.
Widow. Look,
Yes.
will she nowadays the younger generations, they live for their, the profession, for their avocation somewhere, someplace else. The old lady, octogenarian, she is supposed to remain. She can't here and reside alone. She has to go. And if she has gone there, and this is what she has to put under lock and key, But it is always of a temporary nature. It is not a permanent nature,
And he's my nephew, my lord.
whatever. And you are aware that she's not there. Secondly, she came to know that this thing has happened. She came back, found that she lost possession. Main concern is the belongings lying in the house. He knows better in one of the case. When I was at the bar, my client could retrieve something very precious.
The lordship was pleased to summon one of the seal bailiff of Alipur.
No, that was not a case. I was on that side of the room. The thing was that there was already a proceeding going on. Suddenly, my clients, they went to attend a marriage ceremony at Delhi for 7 days. Returning back, they could not open their own house. They found that it is open. They were absolutely in panic. Then they rang bell. Somebody opened it. Who are you? Say, my house, gone. Where? I have taken possession. Look, only certain clothings which they carried for attending the marriage was there and everything gone. And in that community, the lady had a lot of things to do. She used to save a lot of things from the husband, and she used to hide a lot of things from the husband. Husband was not under that amount of panic, but the lady was. You know, very interesting. Then I say, we made an application for that was a courtroom number 2, saying that a special officer should be appointed. He was appearing. He was appointed as a special officer. Sorry. He was appointed as a special officer. Huh? He was appointed as a special officer. Sorry, he was not there.
So that's
Said immediately the inspection has to be done. Then he was appointed as a special officer to go and make an inspection. It was open. Mr. Jivanathan Chatterjee. Yes,
other side.
It was open. Lady requested me to say to him something. What? That she has hide certain amount of money from the husband. Husband doesn't know that she has. So say, please request him that if that money is there, not in front of my husband. My husband should not know that I have.
But your lordship's client got back possession.
So that was the thing. And
Not the money.
I requested him that go make an inventory, record whatever, but do not record in presence of the husband. Otherwise, the husband will take away all the money from her.
But he was the person who was working in Amber. I am still the special officer, holding on to those keys.
But still,
Still
it has not been disposed of.
not been disposed of. Your lordship's officers, clients are.
What happened there in those families?
And Mr. Jivan Chatterjee's client hasn't yet
এই সাহেবের কাছে পাঠিয়ে দাও।
My lord, Your Lordship, may I point out only one? Your Lordship, I am,
Hearing concluded by order.
my lord,
চলো আমার কাছে না
my lord, may I point out only one thing, Your Lordship?
করার জন্য আসবে না by order.
We have read up, my lord.
Your Lordship, may I
We have read.
just point out only one thing, Your Lordship? We had been given back the possession, Your Lordship,
You're
subsequently.
not saying so. Not enter into this. We will be simply concentrating on section 5. Ultimately, if he wins in the appeal before the first appellate court,
140.
then he will take, you have inducted somebody, he will take care of that. He knows the law and he knows what is the consequences.
Wait, wait.
Lord, your lordship permitted me to come back, my lord. I found, my lord, the judgment, not me, my lord, my learned friends, my lord. But Mr. Chatterjee is also there.
Lord, I don't agree, my lord. If an order 7, rule 11 is rejected by the trial court and allowed by the appellate court, it has to be, my lord, a second appeal.
But this
Reverse.
My lord, the trial court, the appellate court allowed, reversed the order, and my lord said that dismisses order 7, rule 11.
That is what I'm
So that's an order under section 96, or a degree under 96, which needs to be, my lord, appealed against under section 100. Here, my lord, from nowhere, the full bench says it has to be treated as an order of remand. Correct?
please take
And that was not even the reference, my lord, before the learned, the honorable A court.
please take page 7. This was your
No, it
lordship-
cannot be, cannot be.
This was your lordship's reference to a larger bench.
The entire
What's the-
submissions were, what happens if the revisional court does something? From there, my lord, if the appellate court has done something, my lord, it is a degree under 96 and cannot be appealed as order 43.
The page 17, paragraph 25.
It is like a legal fiction. Though we are on the same side, my
He's
lord,
very aggrieved, my lord.
but
He
I don't
wants
think
to-
that's the law.
my lord, that is the difference between us, my lord. He wants to.
No,
set the law right.
if he says we can further refer it to a further.
It has to be done.
But
I tell you,
after
lordship.
interim order.
Yes.
We have the difference. He is a civil lawyer. I'm a commercial lawyer. I need an interim order. He can, my lord, thereafter, my lord, argue on niceties of law. We are both, he's my leader in the matter. We are on the same side. But let me admit
But
my.
not a commercial lawyer.
I am no, my lord. I am a very poor man's lawyer, my lord. We are
Yes,
civil court
I
lawyer.
wish half the world
Chotto
was.
family,
100 rupees suit.
100 rupees.
I wish
Declaratory
half the world
100
was as poor as him. You know, there would be no poverty left.
Chotto family, lordship forgot. Chotto family, Chotto.
Well, I wish the world was as poor as him.
He said so.
Well,
Now he
I
can't
wish-
retract.
I wish. Then there would be no poverty left on earth.
No, he's referring something which I know.
Oh, I don't know.
That we were referred to that, my lord, by an honorable court. We were referred to as that.
I'll find out, Milord. I'll find out. But Milord, kindly see, Milord, page 17.
My lord, whatever happens, the matter has to come before your lordship. If we follow, my lord, this judgment, it will be FMAT. And if we don't follow this judgment and follow law, then it will be section 100.
No, this is not paragraph. For now, the issue arises.
But there can be one argument, my lord, which can say that it doesn't amount to a final adjudication. Because ultimately, my lord, order 7, rule 11 is being rejected. There can be one argument to that effect. But it has to be.
আমার entry marker হয়ে যায় তার।
আর সেটা আমিও মানছি ইন্ট্রি অর্ডার নিয়ে নেন।
Milord, please see, Milord, paragraph 25 and then the paragraph wrongly numbered as 47.
What? Now the issue arises when a
Yes.
first appellate court either affirms.
Affirms the order rejecting the plate.
Wait.
Yes, Milord.
Let me read. Affirms the order rejecting the plaint or reverses the order, thereby restoring the suit to be tried on merit. No difficulty. What would be the remedy available to an aggrieved person? Fair question. Is it in the effect an order of remand?
I cannot understand at all. This is unbelievable. Absolutely unbelievable.
It's an order of remand and order 42, 41.
And then it becomes appealable, my lord, as
Order
FMAT.
The suit to be tried and merit is however applicable.
Unbelievable.
And has to be, my lord, admitted first
Like
a second appeal.
It has to be admitted like a second appeal, but in nomenclature as order 43.
I don't know.
My lord, can it show any law?
Yesterday I said, I don't comment. No, I don't know any law. I only, my lord, commerce.
I don't know.
I don't, my lord,
That allows us to, my lord, file it. এটা হতে পারে না। Kindly do it. I'm saying so. But we need an interim order, my lord, in the meantime, because they are coming and disturbing our possession.
The larger.
no,
Yes,
larger
large will not come. My lord, kindly protects us and then sends us. Because this has to go.
my lord, second, we have prepared a second appeal.
That is the law.
Kindly give the leave. Lordship can convert it at any juncture, my lord. Kindly admit it.
Was under that, it will check whether second appeal or something else.
Second appeal or a revision. Or 100 or 115. But my lord, it's a degree under 96. It has to be challenged under
What was
100.
referred to the larger bench is a totally
The
different.
larger bench, my lord, the larger bench was
Observation.
considering something completely different.
Completely different. This
Completely
was
different.
not called for.
Lord, I would say your lordship would treat it as per incurium. Because of the
Cannot,
Daisy man process.
cannot.
Of course, my lord can. If it is beyond law, my lord can.
No, larger bench strength you cannot.
No.
Not
But-
per incurium. There has to be either.
Sub silentio,
Either
No.
sub silentio is also problem.
No,
Either an obiter or not.
definitely an obiter and also sub silentio. My lord, remember Justice S.B. Sinha's decision. It says that if it is not the issue before the court, and if the court passes something, it will go as sub silentio and not binding on the courts below. No, sends it. I have no problem, but interim order.
reference.
Give the leave. let
Please,
us-
please
Leave
give
to
leave.
them.
My lord, may I come at 2 o'clock?
Tomorrow.
It's listed,
No, we'll come tomorrow.
I have not in a single matter.
The only way to get out of it is if your lordship publishes permits us.
No, why? We can come back tomorrow. There
We'll
is no
come
problem. We'll come back
We
tomorrow.
come tomorrow.
Tomorrow না Monday করবি কাল করবি সুরজিৎ দা রয়েছে বলছে
তুই কর না।
সুরজিৎ দা রয়েছে
ও নিয়ে আসবো সুরজিৎ দাকে কাল।
If it appear tomorrow, I think I will be taking up applications first.
You know, kindly permit it.
Will
High
appear
listing tomorrow. Let's have.
and you know the degree hasn't been drawn up yet. I don't know whether they will draw up a degree or not, so that leave is also required. Tomorrow tomorrow can.
Tomorrow it will appear, we do not know whether it will.
But
be
it has to
taken
go
up
to the
tomorrow.
stamp reporter.
Tomorrow, that's why we say it will appear
Absolutely.
tomorrow, may be taken up on Monday.
Very well, very তাড়াতাড়ি লিভটা দিয়ে দাও ফাইল
Grateful.
My lord, my lord, item number 31, I'm for the appellant. I'm praying for after vacation. Your lordship kindly takes it up. Grateful,
Welcome. After vacation.
grateful to your lordship.
Care of the app- এটা তোমার আবার কেন এসছে কালকে তো কোনটা রাখো আগে। ওর ফাইলের মধ্যে রাখো।
Yes, well, yesterday your lordship had the occasion to consider the matter, but
আবার কেন আজকে রেখে দিয়েছো?
since they were on caveat, they did not appear yesterday. We've given them a further notice.
There is another matter, we
বলেছিলাম।
were watching that matter, that is why we missed this matter.
এটা
No,
বলেছি
no, no
কিন্তু
problem.
এটা তো প্রথমে থাকবে ও তারপর থেকে যাবে এই তার আগের ম্যাটার গুলো Yes.
My lord, appeal directed against an ex parte ad interim order of injunction.
Yes. But only one thing, my lord, that order has been extended twice by the learned court below.
So
Your Lordship sees
My lord,
the-
we have filed a fresh memorandum of appeal
Where
on
is
the
that?
extension order.
even thereafter, there is an extension. Yesterday, 10th October, there has been an extension.
So previous appeal filed, one extension, we filed a memorandum of appeal. If I may just draw your lordship attention to the impugned order once. Our first point is that, my lord, if your lordship will see the plaint which starts at page 19, this is that trust.
File further
Trust.
appeal, file further appeal today, taking a leave without the certified copy. Yesterday's extension.
Well, it has been a mere extension. Well, if your lordship's that
But the
view is there,
difficulty is now there is a still, dilemma.
well, in
I
fact,
do not know whether I have a distinct, একটা লার্জার বেঞ্চে একটা আমাদের কাছে পড়ে আছে, ওটা কি ডিসাইড করে দিয়েছি? না, এটা আমার জাস্টিস শম্পা সরকার আর আমার যতটুকু মনে আছে, I have dictated that judgment of the special bench. স্পেশাল বেঞ্চে জাস্টিস শম্পা সরকার আর জাস্টিস রবীন্দ্র সামন্ত ছিলেন। আমার মনে হয় দুটো না তিনটে, দুটো মামলা ছিল, দুটো মামলায় যেটাতে আমি জাজমেন্ট লিখেছি আর একটা জাস্টিস সামন্ত লিখেছে। স্পেশাল বেঞ্চ জাজমেন্ট আমি চাইছি যেটা আমি লিখেছি। File it today.
Any event also, your Lordship can see, well, this is an interim order of August. My lord, it's on the basis of ad interim
immediately
order,
filed.
ad
Immediately.
interim order
I tell you very frankly,
of status quo.
This is a very bitter experience which I had on that side of the room and this side of the. The moment the interim order, ex parte ad interim order is passed by the trial court, it is a humongous task on the part of the defendant to defend that particular interim order, that interim order to be vacated. Humongous task.
Your Lordship can fix your time.
The problem is it continued for years together. And this is why I find, if I am correctly remembering what I have heard, that every extension
Is a mechanical
has to
extension.
be passed by giving a reason. If
That
you
is
do
not
not
done.
pass a reason,
That is not done actually.
that is not done at all.
At all. At all.
And every the
a
order
matter of
extending the interim order is a fresh order.
Yes. It becomes a matter of course in the court.
That is what is happening.
Yes.
We have held so.
They just
When
put
we
up a petition.
We wanted everything to be settled in this regard. If somebody comes and opposes, you must record the submission.
And you see,
And then I
not even a sentence.
I am not
Interim
standing
order
in
is
the way of
extended
this
till
appeal
date.
being taken up. I am not
don't have to
standing.
say so.
I can
I
understand.
am also saying that. It's a matter of regular practice. I am not standing in the way, but what I am saying is.
No, that is why we wanted that everything has to be done on the basis of the merit.
Yes, yes.
My lord, this is,
So the necessity of this.
my lord, then, my lord, if this order sustains, Shiv Kumar Chadda, Morgan Stanley,
that is-
giving reasons, order 39 rule 3, and then it's a sued by a trust.
Main order does not suffer from that. Principal order which you have challenged does not suffer from the Shiv Kumar Chadda violation.
File it today. My lord, then kindly give us leave because we will not get certified copy.
Go apply for a certified copy today, immediately file with that copy.
With that,
Means the application applying certified copy.
Correct,
will be
correct.
validated 10th.
correct.
Please do it. Give a
Lordship
leave.
officer will give us that leave to file it.
Give a leave.
Very well,
You must annex that you have applied for certified.
very well. Then Lordship just makes it not today, we'll come back tomorrow. My lord, great. Tomorrow. Monday নেই, পারো। মানে কালকেই করে দাও। তাহলে কালকেই করে দাও। কালকে। কোথায় থাকবে?
Memo of appeal
আরে
আপনি
তুমি
solve করেছেন?
করো না, ফাইল করো না।
এই ওটার memo of appeal আমাদের down পরের যেটা আছে আরেকটা।
দাও। এনো।
আমরা চাইছি।
এত চিঠি ছাড়ো তো এনো।
Max, নয়, অনেক আছে।
বললাম বুঝলে কি বললো যার সাথে বুঝলে আমি বলো কপি করে অ্যাপ্লাই করে কাগজটা পাঠাবো এটা দিয়ে দিয়ে লিভ নিয়ে মেমোটা নেক্সট
What is the defect?
defect
Any- Nowadays, nobody is caring to write the name of the judge. Which order is under challenge? 15-9?
59
Just give us 30 seconds time.
কোনটা মেমোতে আছে দিয়ে দাও
We have to admit the appeal and hear after the vacation, but we can't stay the operation of the order. My own judgment is staring at my face. At the time of admission, I can't do it.
well one thing my lord I
But I have seen there is
the
a
replica of the earlier one. What is followed from lordship on the earlier occasion, my lord was pleased to set aside the judgment, holding a mere filing a suit or partition does not means passing an order of injunction. My lord remanded the matter by setting aside the judgment directed to hear afresh.
now. May I make you wise and to his detriment?
That order was bereft of any reason.
No, I am asking you. May I make him wise or to your detriment? One point that stuck in my mind, and there is a judgment of the Supreme Court on that. I do not know whether he will take that point or not. The appeal is admitted. Since the appeal arises from an order by which an application for temporary injunction is disposed of, we do not think that there is any necessity of the preparation of the paper book for the purpose of disposal. Full stop. We therefore dispense with filing of the paper book. Both the parties are directed to make a compilation of the documents relied upon by them in support of their application, in support of the application, in relation to an application for temporary injunction on the next date of listing. list the matter for final disposal under the heading for order on 16th of November, first day. We are reopening on 16th of November. Any difficulty?
For me is no difficulty. I'll be here.
First day, many people will not do. I think both of you are here so that we can do it.
First day, my lord, actually what happens, my lord, the compilation has to be done. My lord, the lower court.
You have a 1 week with you. You get it prepared
Where's the
and keep it with you. Only thing is an application for temporary injunction, opposition,
Yes, my lord.
reply, and
the
if there is any
documents will be
document by way of Firisti, those are to be included.
Documents, sir.
That's all.
Lordship, I'm for the appellant, Lordship. Lordship, the plaintiff is the appellant before your Lordship. By the order impugned, Lordship, my prayer for ex parte ad interim injunction has been refused.
Just give us 30 seconds time.
Order dated, Lordship,
Yes.
order number 2.
We have seen that, 19th of September.
Lordship.
Where is that letter of the advocate?
Lordship, the advocates at page 39, Lordship, of my injunction application.
38.
39.
Oh, 30. It starts from 38. 8/9/2023 is a letter.
Lordship.
It starts from 38. What is the date of the agreement?
Lordship. That is, Lordship, 3rd July 2020.
3 years period was there.
Yes.
Where is that agreement?
Lordship, the agreement starts at page 22.
How 10 lakh was paid? Check.
Lordship, that is not indicated here. But Lordship, this agreement says that he has received Lordship.
How you have paid?
There is no separate Lordship memo of consideration.
I understand, but have you stated in your claim that how you have paid?
Lordship. Lordship, cash. But Lordship will kindly appreciate, Lordship, the relationship between the parties, Lordship.
Hey, sister and brother-in-law, I know. Cash. In
Yes, Lordship, that
2020,
too during the
2020.
pandemic, Lordship.
In 2020,
Yes, during the pandemic, Lordship.
10 lakh rupees cash during the pandemic.
Lordship.
Believable story.
But Lordship, in the ex parte ad interim stage, Lordship, I have produced everything. But the learned trial court has rejected on the ground that I could not
That's the
produce.
only thing is that you were in position. You were
Yes.
given creating a licensee. Now it is a separate issue unconnected with the specific performance agreement.
Lordship.
Now you were not given a position under section 53A that you can protect your position under that agreement.
Lordship.
Even if it is given, you can't protect it.
Lordship.
It's an unregistered.
Lordship, that can be taken care of in the suit, Lordship.
No, that's why I say section 17 capital 1A
Lordship.
subsection 1A. It takes away your right under section 53A.
But Lordship,
Now you are a licensee. If they issued a notice of revocation of license, that does not mean that your position is to be protected by this order. That is a separate status.
true. But no, Lordship, what I am praying is, Lordship, not to create third party interest. I'm not.
There is no document forthcoming where
But Lordship,
it
I have
says
specifically pleaded that, Lordship.
no.
No,
he
Lordship,
did
what
not do.
document can I produce, Lordship,
No,
that he is trying?
only thing is that he is showing it to somebody else, but the letter which you have relied upon
Yes,
does not indicate. He says that please go out. I want to use it for myself.
true.
So the court has also said that since there is no intention to divest
But
or
Lordship,
part
I
with
have
position,
something, Lordship,
And-
to go to trial.
what for? What trial is the agreement for sale?
True.
But here, an
But he should
injunction,
create the third party interest,
here
Lordship.
is the element. There must be something.
But Lordship, I have, Lordship, pleaded that.
Somewhere. Mere the documents does not indicate, rather goes against you.
Lordship, even the agreement says that, Lordship, I am in possession.
Correct. That's why I say 53A, you can't get an injunction.
But
Look
Lordship,
at the Registration Act. এই কোথায় আছে Registration Act টা দাও? No, I am giving you. I have. Registration Act টা দাও। এখানে পাচ্ছি না। ছিল তো এখানে। 17(1)(a). One capital A is the another section after 17(1). Subsection 1A introduced subsequently of which year? This book?
2017.
Oh, it is there. 2003 or 4, the amendment came. Give it to me. Look at it. এটা দেখো, এটা যেটা থাম দিয়েছি ওই জায়গাটা দেখো। Read this subsection.
True, Lordship.
So now there are two things. You can protect your position under section 53A, provided the position is given in part performance of an agreement for sale.
Lordship.
If somebody wants to take away the position, that's the protected right, protected position you can. It is not a case like this. Because you never said that you got position in part performance.
Lordship.
Now there was a license which was created in you. That's a divorce the agreement for sale.
Lordship.
Absolutely a new right. If that being the position, if you wanted, he has issued a notice that you give back the position. That's a separate issue, unconnected with this specific performance.
Lordship.
So in that event, why the injunction to protect your possession? Secondly, if you say that they wanted to create a third party interest by selling it to outsiders,
Lordship.
there must be something which should be there.
Lordship, I
Well,
pleaded.
Correct. But the document which you have relied upon, had there not been this particular letter, we could have understood. But the letter manifests the intention, and the intention is not to sell out. He wanted to use it for himself. If that being the intention, then there is no emergent situation where the ex parte to be passed. He is to be notified, and there in their presence, the matter has to be.
Today, Lordship, again sells it to some third party, Lordship. My suit will become
Kindly-
more complicated.
Please try to understand. When court can pass an ex parte ad interim order of injunction, under Order 39, Rule 3,
Lordship.
the normal rule or the general rule is that no court should pass an injunction, interim order of injunction, unless he notifies the defendant. Defendant has to be heard. The exception is that if the delay would defeat the very purpose of the injunction, then the court is vested with the power to pass an ex parte ad interim order of injunction upon recording of reasons, therefore. Now, the question is whether it is such an emergent situation which cannot wait till the defendant is given a notice.
Lordship, these
Here,
advocates.
here you may have said that this is there, but the letter which you are relying on, and part of this, shows that he does not have any intention.
Lordship, it shows
Rather,
that he has no intention,
reverse.
Lordship, to respect the agreement, Lordship.
Now, whether that can be a ground for injuncting him,
Lordship, that coupled with my pleading, Lordship, in my application.
can it be a ground? Show me one judgment, I will be happy to
But
extend
Lordship,
this.
whether now he's trying to create third party
Where
interest,
is that?
where, Lordship, how will I get any documentary
Madam,
evidence?
here, he wanted to say that
Vacate the property, lordship. Here also he is saying vacate the property. He does not want me in that property, lordship.
No, why he says that since both of you, being the sister and brother-in-law of my client, were having an issues residing in your matrimonial house, you were allowed to reside in the said property as a licensee by my client. It is to be noted that you and your husband has been residing since 2008, and despite any client, kindly visualize, it is prior to the agreement. Despite my client letting you know that my client reasonably require it for personal use on multiple occasions, you have not delivered the vacant and feasible possession of the same. Take notice that my client requires the said portion for the purpose of using it as a personal residence.
Lordship.
You are hereby directed to quit vacate. So
Lordship.
intention is laudable that they do not want to sell it. They do not want to give in possession of anybody. They wanted to, or means other side wanted to use it for his purpose, which he can. He is still the owner.
True, but lordship here, lordship will kindly consider if lordship today expert, if he creates lordship third party lordship interest, because
Sorry.
he has not lordship said anything about my agreement.
No, he should not. That's a different issue. The instant appeal arises from an order dated 15/9/2023 passed by the learned civil judge senior division first court Kontai in OS number 25 of 2023, by which a prayer for ex parte ad interim order of injunction is refused. The aforesaid suit was filed for specific performance of an agreement for sale, wherein the total consideration price as agreed upon is shown as 50 lakhs. Stop. It is claimed by the plaintiff appellant that out of the aforesaid total consideration amount, a sum of rupees 10 lakhs was paid as at the time of execution of the said agreement. It is further stated that the period for completion of the transaction was agreed upon by the parties to be completed within 3 years from the date of the execution thereof. But on being requisitioned by the plaintiff appellant to execute and register the sale deed, there was a reluctance on the part of the defendant respondent. Obviously, the reason for refusal to honor the terms and condition of the purported agreement is a cause of action for the purpose of filing a suit for specific performance of an agreement. An application for temporary injunction was taken out, seeking an order of temporary injunction upon the defendant respondent to the effect that he will not create a third party interest in respect of the suit property till the disposal of the suit. It is indicated therein that there is an intention apparent from the conduct of the defendant appellant, defendant respondent, to create a third party interest, and therefore, unless unless the ex parte ad interim order is not passed in this regard, it would cause immense injury to the plaintiff appellant. The trial court refused to pass an ad interim order of injunction on taking into account the letter dated 8/9/2023 issued by an advocate on behalf of the defendant seeking the possession of the suit premises. To stop. It is sought to be contended that there is a clear averment in an application that the defendant respondent is trying to create a third party interest in respect of the property. and therefore the court ought to have passed an ex parte ad interim order of injunction pending a suit for specific performance of an agreement, for the simple reason that if any third party interest is created, it may invite the third party to be implemented as a party who, under the equity, may claim or may take a defense as bona fide purchaser for value without notice. We do not find that mere an apprehension would invite the court to pass the ex parte ad interim order of injunction. Apart from the existence of a prima facie case, balance of convenience and inconvenience, the court should weigh the claim of the plaintiff appellant on the parameters of an injury to be suffered in the event the immediate protection is not provided. Though the plaintiff appellant has averred in the application for temporary injunction that the defendant respondent is attempting to create a third party interest, but from the tenet of the letter produced before the trial court, issued by the learned advocate on behalf of the defendant respondent, we find that that the defendant respondent wanted the possession of the suit premises from the appellant respondent upon revocation of license. The intention is laudable from the language used in the said letter caused by the learned advocate on behalf of the defendant respondent, that the appellants were permitted to occupy the suit premises as licensee in the year 2008, much before the alleged execution of the agreement for sale. The notice seeking the possession upon revocation of license cannot be construed as a good piece of an evidence in relation to an allegation that the defendant respondent is creating a third party interest. Furthermore, it is manifest from the content of the said letter that the defendant respondent wanted to use this suit premises for his personal use, wanted that suit premises for his personal use, which ruled out the apprehension that after taking possession, third party interest shall be created. Apart from the same, once the notice revoking the license is given, the intention which could be gathered therefrom is that a proceeding for recovery of possession would be initiated, and until the actual possession is delivered to the defendant respondent, it cannot create a third party interest by putting him in possession. We thus do not find that the findings returned in the trial court warrants any interference in the instant appeal. The appeal is thus dismissed, no order as to cause.
Okay.
It is, however, made clear that the observations made here in above shall not be construed to have any persuasive effect at the time of considering the prayer for interim order or disposal of an application for temporary injunction in presence of both the parties.
Okay.
Let's call the next. Yes.
May it please, Lord. This is by plaintiff, Lord. Lord, against an order refusing.
No, sorry. No. Bull.
By plaintiff was an owner of a plot of land, Lord, is coming up against an order, Lord, refusing him ad interim relief against Lord encroachment by his immediate neighbor.
Just 1 minute. Can you give me 30 seconds?
Yes.
Order dated 25 September is under challenge.
Yes, that is so.
Where is your application for temporary injunction?
The application is, Lord.
Page 14?
Page 14. Page 1. Paragraph 10, Melodar. In a nutshell, set out the grievances.
Where is the photograph? You say that is a case of an encroachment on the another property which was not the subject matter of
No,
development.
encroachment on my property.
You said that the property where the encroachment has been made was not a subject matter of the development agreement, and therefore he is making a construction by encroaching upon your portion.
Yes, he's making
Because
a,
your holding number,
making a
which was under
construction
the
upon a-
development agreement, was 545,
yes,
and he wanted to encroach under 543.
yes, that is so, Milord, with the side space and the back space, Milord.
Oh, I understand.
Yes.
So this is what I really wanted. Where is the photographs?
The photographs are here, Milord. Lordship can look at the page 115, Milord. Photographs speaks for itself. 115 is the photograph that Lordship will find. Milord is putting up some bamboo poles there as a telltale evidence of his intention. On the right hand side is my property. His property is in the left, on the back side, Milord. The black building on the black side, where a shopping arcade is coming up. The left hand side, Milord, somebody else's property. The right hand side is my property, and this is the space, Milord. Milord, the side space, Milord, and also the back space is there in between. Here he is trying to, Milord, make the encroachment. And with that intention is being, I believe Milord is going to. Milord, there is no.
The appeal is admitted. By virtue of a development agreement, development agreement was in respect of
My plot,
which one?
my developer,
540,
543 GT Road. That is my plot.
and what is 545?
541 backside. I've got no Milord, no track with 545 is the backside. He's encroaching. The backside owner Milord.
He's not a developer.
He's not a developer, he's an owner of his own plot, 545.
They are the Ramratan
Ramratan Jyoti.
is an adjacent plot holder.
On the backside, yes, adjacent plot holder.
He is making, not your developer.
Not my developer. But I have no complaint with my developer. Other issues are there. Okay. Encroachment, I've got the complaint. Encroachment is only with Milord, the backside plot owner.
The plaintiff intended to construct a G+8 storage building at municipal holding number 545 GT Road South and entered into a development by virtue of a full stop. There is an adjacent municipal holding number 543 which is owned and possessed by the respondent.
545.
545 is your.
My 43
Okay,
is
sorry, 543 hobe eta. Acha, adjacent plot is 545.
On the backside.
And your one is a G+8 storage building.
He is bringing, mine is G+4 and he is bringing up 545 G+8. The huge shopping.
And development agreement was entered into between whom?
Between myself and my promoter in respect of 543. Milord, I've got an issue in this suit with my promoter. Those are different.
But the trial court has recorded something else.
Milord, trial court is Milord recording Milord my issues with my promoter, and then Milord trial court is going on the fact that Milord Lordship comes to the last paragraph. My issue with my promoter is entirely different thing. That's not subject matter of this suit. My complaint is against 545. That is my backside plot holder. Who is trying to encroach?
Where is the plaint?
The plaint is here. Thank you, Lordship. Plaint. Yes. This is a copy of the plaint. Paragraph 3, I've stated, Milord, I'm the owner of 545. 543. Sorry. Defendant is the owner of 545. Paragraph 3, I've stated. I've annexed my title deeds also, Milord, regarding 543 GT Road.
Lekho, get it out. Appeal is admitted. By virtue of a development agreement, the plaintiff appellant developed the property being the municipal holding number 543 GT Road within bracket South Police Station Howrah by constructing a G+4 storage building. Full stop. There is no dispute that the plaintiff, sorry, it is categorically averred in the plaint that they are possessing and owning the said property, and the defendant respondent has no right, title, and interest in respect thereof. It is categorically averred in the plaint that the defendant respondent owns municipal holding number 545 GT Road South, Howrah, and recently started making a construction thereupon, and taking advantage of the situation that there was no demarcating wall, he encroached upon the portion of the plaintiff respondent by putting a bamboo and is stacking the building materials. Stop. The photographs annexed to the injunction application also revealed a vacant portion where several bamboo structures have been put. Stop. The trial court refused to pass an ex parte ad interim order of injunction as the photographs does not reveal that any illegal construction or encroachment has been made over the suit property. The moment the plaintiff appellant has categorically averred that such encroachment has been made, and the photographs reveal that there is an attempt to make construction thereat, the court should immediately protect the interest of the plaintiff. Stop. In view of the above, there shall be an ad interim order of injunction restraining the defendant respondent from making any further construction at the where is the schedule?
That is the page, my lord. In schedule to follow.
Very bad
Page
way.
21. Page 21.
Very bad way. No. You have included the entire property. Cannot be. You should carve out in another schedule so far as that portion is concerned.
My lord, side space and the back of this.
That cannot be. That should have been measured like this.
Been measured, but that's so. It's been done.
It should have been. You will see. Over and above the premises number 543 GT Road South for a period of 10 weeks from date or until further order, whichever is earlier. The appellant is directed to serve the copy of this application upon the respondents by speed post and shall file the affidavit service on the returnable date. The application is made returnable 1 week after the reopening of this court following the summer vacation.
Already Lordship has said restrain from making any construction or encroaching
Further construction.
or encroaching upon.
We can't say so.
Because
Can't make a further
I
construction.
will next my cell deeds. Very well.
That will be ascertained
That will give
later
the
on.
adequate protection.
It will only depend upon the investigation to be done by the survey pass commissioner.
That is so. Obliged.
So we say only no further construction.
No
We
further
can't demolish the existing one. Sorry.
Much.
I am for the appellant. My application under order 9 rule 13 was rejected, my lord. My lord, I appeared in the suit. I filed WS, and after filing the WS, he requested me for the settlement. There is a settlement. My losses can see judgment. Last one, my lord, dated 5th December 2022. There is a settlement in the Gram Panchayat office, and he assured that he will take steps to withdraw the case because I stated that the plaintiff has no share in this suit party. It is a partition suit.
Which degree you are assailing?
My lord,
Which degree you are assailing?
preliminary degree, against the preliminary degree, which was informed in 2015 and immediately 2019.
Was there any document in that particular compromise?
Yes, it was in the Gram Panchayat office was there, and the Pradhan came and gave evidence. Then asked me, what is your certificate that you are now Pradhan? But that time I was Pradhan when the settlement took place.
No, there was any writing.
Yes, my writing in the Gram Panchayat office.
Where
It is
have you
also
produced that writing? That this is what the parties have signed.
Annex
Settlement
nine.
has arrived.
Annex 9. Annex 9.
Huh?
And evidence has given by the Pradhan in the EML.
That will not do. I'm just.
Then I have to request my.
No. Have you produced it?
Then
have you produced the written agreement that settlement? This is what the signed by the parties.
original to come.
They have settled.
Then lots of kindly get after vacation. Well, I'll try to get it.
On the prayer of the appellant, let this matter be listed after vacation.
But I beg to differ for the appellant. On the last occasion, my
Why
lord,
you
direct,
beg?
my lord, I need to not to beg, my lord. Kindly pardon me, my lord. It's a habit.
You have a right to appear. Say, I'm appearing for the appellant. Why you say?
Appearing for the appellant, my lord. The last occasion, my lord, directed to serve upon all the respondents, my lord. I have served, but a talks of settlement is going on since it's a partition suit, my lord. Total 16 settlement is going
That
on.
was also indicated
Reflected
on the last occasion. Then
Yes, but it will take some time as so far to the
the
instruction from
learned
the client.
advocate appearing for the appellant submits that substantial progress has been shown in the settlement, and therefore let this matter be listed after the reopening of this court following the puja vacation.
But I have filed the affidavit of
Stop.
service.
In view of the above, list the matter accordingly.
I have
Affidavit
filed
of
the affidavit.
service be kept on record. Next.
Keep your place.
Same matter, family coach, I do not know. Not today. Next. After vacation. Hey, 2016-15. देखिए আগে হয়েছিল কেন? এরে সইও হয়নি অর্ডার, সিগনেচার নেই। এটা আমার কাছে পাঠানো হয়নি কেন? তোমার উইদাউট সিগনেচার চলে এসছে 5 তারিখের অর্ডার। No. Then appears. Oh, চলে এসছে।
39 and 40.
Yes.
I am paying for short password. Let the
Then let it appear. An accommodation is sought on behalf of the appellant. Let this matter be listed after vacation. Next.
kindly
Sorry, after vacation. 2015-16 matter pass over. No,
My senior, he is engaged in another court, lordship.
Maybe let him engage, do another matter. He's not interested in this matter. Next.
My lord, I am appearing for the appellant in this matter. The suit was, my lord, for compassionate appointment to declare that plaintiff.
Suit for compassionate appointment.
Yes, my lord, because previously there was one round of litigation before the Honorable High Court where the Honorable High Court asked that to decide the question whether the plaintiff number 2 is the adopted son of plaintiff number 1. May I place that order, my lord? In accordance with
What
that.
is this FME? Oh, 41 SAT.
SAT, my lord. Now that suit, my lord, was dismissed.
That's a suit for declaration that you are an adopted son.
Plaintiff number 2 adopted son or plaintiff number 1.
Yes.
But that suit was dismissed on the ground that there was no valuation statement in the plaint. We filed an appeal saying.
How can there be a valuation?
Yes, my lord. If your lordship kindly has a look at the plaint, we have put a caption that suit for declaration. But in spite of that, my lord, the learned trial court did not accept that and said that it is to be dismissed because there is no valuation statement. We said that there cannot be valuation statement of this type.
Sorry, suit is not dismissed. The plaint is rejected.
Yes, plaint rejected under Order 7, Rule 11, my lord.
Is there a distinction between a dismissal of the suit and a rejection of the plaint? Don't you know?
Yes, my lord. Yes, my lord. Against that, my lord, we preferred an appeal before the learned appellate court. But the learned appellate court said that there is no list of documents given and annexed to the plaint under Rule 14.
Just can this be a ground? What the appellate court did?
Appellate court, my lord, dismissed on contest and on the ground that documents are not annexed to the plaint.
Where is the appellate court judgment? The appeal shall be heard on the following substantial question of law. Whether a suit for declaration of the status requires a valuation a suit is required to be valued by the plaintiff, as there is no other mode of ascertaining the valuation under the Court Fees Act. Oh, stop. Sorry, question mark. Next, whether both the courts below were justified in rejecting the plaint solely on the ground that the plaintiff has undervalued the release without indicating the relevant provision relating to valuation of the reliefs in a particular manner provided under the law. Service of an application returnable 1 week after vacation.
Grateful, my lord.
Next. Undervalued.
That, 42, my lord, I am also for the appellant. In this case, my lord, a preliminary decree was passed in a partition suit. We challenged that in by way of an appeal that there exists a will and therefore there is no scope for partition. Now, on the day of the hearing of that appeal, my lord, the petitioner number 1 fell ill and could not attend the honorable court, and on that ground the suit was dismissed on default. And we filed an order 9 rule 9 application for restoration of the suit. But however, learned appellate court said that along with the medical certificate, we also should provide the prescriptions. And because we did not provide the prescriptions, therefore the appeal was dismissed. This is the basic point, my lord. That whether prescriptions is required to be provided along with the medical certificate.
Wrongly stating the facts. By the impugned order. Now, see, the appeal filed by the appellant was dismissed for default, as the appellant could not remain present on the said fateful day. An application for readmission of an appeal under Order 41, Rule 19 of the court was taken out, and by the impugned order, the same is rejected by the court. This is the correct fact.
Yes, my lord. I apologize, my lord.
After perusing the abovements, we feel that the matter requires hearing in presence of the respondents. Accordingly, the appeal is admitted. Service 1 week after vacation.
Grateful, my lord.
Yes.
By the impugned order, my lord, the ad interim order has been refused. Ad interim order of injunction has
If a court has a power to grant, the court has a power to refuse. No difficulty.
If your lordship.
So what? Merely he has refused.
No.
So illegal.
No, I am not saying.
Just give us 30 seconds. Who is the defendant? Where is your application for temporary injunction?
No, it is annexed with the application.
Warning of a murderous consequences. What English is this? Where is your deed?
No.
Where is your deed of 1983
And today I am,
after vacation?
no, may I serve and come back?
No, sir. Show us the deed. Show us the deed.
During vacation, if I serve in that event, it might be
No,
not in
no.
presence of the other side.
Bad person for this. Unless I am satisfied, I will not. 44.
Lord, I am such my lord plenty appellant. My lord, the suit for my lord partition and my lord declaration. My lord, during pendency of the my lord suit, some of the defendants, my lord, illegally and forcefully trying to my lord
Which order is under challenge, sir?
my lord, that is
29.6.
page 8. 29.6, my lord.
Yes. Give us 10 seconds time. Where is the plaint?
Plaint, my lord. My lord, that is, my lord, next page. My application, page number 9.
This is a suit of dismiss partition among the concept of the joint family. Then yes,
My lord, para 3, my lord, I have, my lord, specifically stated, my lord, that, my lord, some of the dependents, my lord, some portion of the, my lord, joint property, they are, my lord, trying to, my lord, construct and, my lord, create.
first thing is show us the joint property. How that becomes a joint property.
My lord, in, my lord, each and every apartment, my lord, I have stated that, my lord, I am the co-sharer of, my lord, 1/4 share.
How?
How, my lord? As because, my lord, the original owner,
Property was purchased in what name?
my lord, that is, my lord, after, my lord, filing the suit, my lord, they disclosed that, my lord, the property was purchased and, my lord, partition, and that has been challenged in my suit also. And, my lord, that is, my lord,
How? On what ground you have challenged that?
as because, my lord, they, my lord, disclosed the deed of 1985, but they have not given effect to that deed, my lord, till 2020. And, my lord, we are enjoying the entire property jointly, my lord. They, my lord, first time disclosed about the, my lord, said deed when, my lord, I filed this suit.
Now, deed what? The original owner have sold in their name. That is their claim.
My lord, original owner, my lord.
And the record of right was also appearing.
My lord, original owner, my lord, the Momtaj Hussain and, my lord, Muhammad Oes Ali and Muhammad Karim Sheikh. And, my lord, we are the, my lord, heirs of Muhammad Karim Sheikh. And, my lord, we are enjoying the entire property jointly without any disturbances from.
From where you got it that these persons are the owners?
Page 30, my lord, I have stated, my lord, that
we are enjoying the property with.
No, that is your contention, you are in possession jointly. But I'm just thinking, because you have challenged many things. On some score, you have challenged, you have taken a plea of Benami. You have taken a plea of joint family.
My lord, that is my lord Benami in respect of the my lord, the property which they, my lord, they disclose, my lord, after lapse of, my lord, at least 35 years.
I'm asking you, sir. You have taken two plea to establish your right. One is the Benami, another is the joint family. Now my query is,
My lord,
after 1988 Act, can you take a plea of Benami? First. Second is, whether there is any concept of joint Hindu family in the Mohammedan law.
my lord, your lordship,
You said that from the common fund it was purchased, everything you have said. Whether there is any concept of a joint family under the Mohammedan law.
and my lord, kindly, my lord, come.
Answer me.
My lord, I have, my lord, specifically stated in, my lord, page 16, that, my lord, the ওয়েসালি ওয়ারিশনগণ অর্থাৎ বাদীগণ প্রাপ্ত হয় ওয়ারিশন on the basis of the legal years, they are entitled to get the share of the property, and they already recorded their name in the, my lord, record of
You are avoiding two questions which the bench put to you.
my lord.
I put two questions to you. Answer that first. I have seen in the plaint that you have taken a plea of Benami. Whether you can take the plea of Benami.
My lord, then, my lord, I have to, my lord, produce the, my lord, the record of rights and, my lord,
Whatever. You yourself have said that it is taken in their name, but it was actually the joint family. It was taken in the Benami of their name.
my lord, that is, my lord, a portion of land. But, my lord, I, my lord, prayed injunction only for only one document.
What is that dark?
That is, my lord,
Let us see. What is that
plot
dark?
number 51 and 51 by 165.
Yes. How you have derived title in 51 and 51 by this? What you have stated? How? Which paragraph you say that the 51 and 51 by this?
My lord, paragraph 9, my lord, of my plaint, my lord,
Correct. What you have stated about this?
about the, my lord, say you, my lord, last portion, my lord, drug number 51, খতিয়ান নম্বর 81 মধ্যে দাগের নম্বর 51 LR 51 by 165 পরিমাণ 28 শতক and RS খতিয়ান নম্বর 72 such and such 31 শতক ডেসিমিল সম্পত্তি মমতাজ হোসেনের 8 আনা, আব্দুল করিমের 4 আনা ও ওয়েস আলীর 4 আনা করিয়া অংশ ছিল। একুনে তাহাদের মৃত্যুতে মমতাজ হোসেনের ওয়ারিশগণ, আব্দুল করিমের ওয়ারিশগণ এবং ওয়েস আলীর ওয়ারিশগণ অদ্যতন এজমালিতে ভোগ দখল করিয়া আসতেছে, যাহার বিবরণ আজকের 7ম দফায় বর্ণিত হইল। 7 শিডিউল মেলাড I have stated উক্ত অনাথপুর মৌজায় সম্পত্তির মধ্যে 25 নম্বর দাগে 8 শতক, this is not my lord related to my application for injunction. And my lord, last portion, my lord, that my lord 51 নম্বর দাগে 3 শতক and my lord 59 নম্বর দাগে 1 শতক এবং 61 নম্বর দাগে 2 শতক বাদীগণ প্রাপ্ত হইবে এবং বকরির সম্পত্তি বিবাদীগণ প্রাপ্ত হইবে।
How you will get it? I do not get it.
Well, in inheritance, my lord, I am, my lord, entitled to.
Where first thing is that you'll have to show that this property was purchased jointly by this Mumtaz Hussain, Abdul Karim and OS Ali. Show us from where you got that this property stands in their name.
Then, my lord, can you make it next week, my lord? I shall produce the, my lord.
is required.
First, you'll have to show your prima facie right.
My lord, on the basis of the record of rights, my lord.
Sure, that is not here.
My lord, that is, my lord, recorded the name of my.
Where is the document? It's not here.
My lord, then, my lord, your lordship, can you take up?
Then after vacation,
My
nothing
lord,
more.
can you take up next week, my lord?
Next week, unnecessarily big. You are unable to gather it. You did not produce that in the trial court. Why we will say the trial court is wrong? The trial court has said that I need that these defendants must be here.
My lord, the defendant, my lord, trial court, my lord, specifically stated that defendants are not participated in the suit, but my lord, facts remain that defendant number 25, against whom I prayed for injunction, he, my lord, appeared in the suit, and subsequently, my lord, he, my lord, disappeared. But, my lord, he continued his illegal work. That is, my lord, my case, my lord.
আমরা দেখছি কিন্তু এটা কি আছে এই যে ওরা অ্যাপিয়ার করেনি বলে আমি ইনজাংশনটাকে serve the notice and come back. Appeal is admitted, service returnable, application returnable 1 week after vacation.
My lord, sir, my lord, upon only, my lord, the contested defendant against whom, my lord.
No, they say they did not appear, that is the reason.
My lord, I, my lord, prayed.
Everybody, all the co-sharer, लिखे दाओ. Every respondents.
হ্যাঁ, already respond. এই যে 8 জন। 8 জনকে দিয়ে।
Your Lordship, Advocate Prosenjit Mukherjee is appearing on behalf of the appellant. I am praying for not to.
After vacation. Yes. Accommodation sought for on behalf of the appellant after vacation. Next. None appears after vacation. 46.
This was suit for declaration, my lord. Suit was decreed ex parte, my lord. Thereafter, my lord, the defendant number 3, my lord, filed, my lord, an appeal, my lord. They had not filed an order 9 rule 13, my lord. They filed appeal, my lord. In that appeal, my lord, the appellate court has taken evidence, my lord, Indian appeal court, my lord, and my lord has said that to remand back, my lord, and have to file written statement, my lord.
So what is the wrong?
My lord,
Appellate court enjoins all the powers that of the original court.
but in one of in this suit, my lord, the defendant had appeared, my lord. If your lordship sees, my lord,
Whatever the appellate court thought it fit to remand, then
but
where is the
the
difficulty?
appellate court
Then
has not.
if it is an order of remand,
My lord, it has sent back on remand, my lord.
then
To
how
file
the
written
second appeal
statement.
lies?
Read.
How the second appeal lies if it is against an order of remand?
My lord, this is, my lord, title matter says
Is not a, is not
title
a,
appeal.
yes, where is the,
Order matter page 59
yes, then
order
how appeal, second appeal lies, tell us, against the order of remand? Tell me.
may come back, Malord. May come back.
You have not seen the stamp reporter's report? You
But-
never care to read it?
Malord, in the
Correctly said that it can't be SAT. How it is registered as SAT?
Malord, in the list, Malord is not showing as defective, Malord. That's why, Malord.
No, no, this is absolutely. That's why you will not care
That's
after
my mistake.
filing it.
My mistake, Malord. My mistake.
Sorry,
My mistake. Malord. I have to see.
the seen the report of the stamp reporter appended on the reverse of the first page of the memorandum of appeal, wherein it is indicated that the instant appeal, that the second appeal is not maintainable. We find from the record that the appellate court, after setting aside the judgment and decree of the trial court, and upon allowing an application for additional evidence, remanded the matter to the trial court to hear out the phrase. The second appeal against the order of remand is not maintainable. In view of the provisions contained under order 43, rule 1, within bracket U of the Code of Procedure, as the instant appeal has to be registered as first miscellaneous appeal. Let the file be sent to the filing section for assigning of to assign to register the instant appeal as FMET. So after the completion of the aforesaid exercise, let this matter be listed after the puja vacation. Next,
I should have.
under the heading order 41 rule 11. None appears after vacation. 48. Same.
Malord, I am for that.
Yes.
Plaintiff is the appellant before your lordship. Suit for declaration and recovery of possession.
Dismissed
Malord,
by both the courts below.
No, Malord, the trial court decreed the suit. The appellate court reversed the
Why the
Malord,
appellate court
on the
reversed?
ground that the defendant got title over the property by way of adverse possession.
Was the plea of adverse possession taken in the trial court?
Yes, yes, yes. Yes, take.
Why the trial court refused it?
The trial court said that the defendant failed to prove in the adverse possession, but the appeal court although held that the defendant could not prove, but Malord, kindly come to the appellate court order, Malord, internal
Which page?
Malord, one. Malord, kindly come to internal page 21 of the appellate court judgment.
Which paragraph?
Last paragraph, the defendants are able to prove that they are in possession of some portion of the suit plot number 211, but the defendants failed to prove that they are in adverse possession of some portion of plot number
111 as against the plaintiff because the defendant by their pleadings and evidence has denied the ownership of the plaintiffs over co-scheduled property through the Solonama decree. The defendants challenge the legality of the Solonama decree. So the defense of the defendants regarding adverse possession against the real owner, which is a major requirement for proving the adverse possession, is missing in this case. Now, at point number 2, this point was framed upon the question as to whether the learned trial court had erroneously directed the defendants to remove the construction over the stand over the ABCD co-scheduled land and to hand over its possession in favor of the plaintiff within 3 months from the date of the judgment. Otherwise, the plaintiff shall be at liberty to execute the decree as per law. Regarding this point, this court finds that without local investigation, it cannot be decided as to the real position of the defendants over the suit land. All the exhibited documents from the side of the defendants, whether relates to M. Mark room as claimed by the plaintiffs or ABCD lands as claimed by the defendant, is not proved before the trial court. In page number 20 of the judgment, trial court opined that all the
How
documents
he has framed those points, whether those issues were there.
with regard to my lord, these demarcation.
What is the
No, no, no.
is framing a point,
Yes.
whether those relates to an issue.
No, my lord, kindly, my lord, he refers to page 20 of the trial court's judgment. My lord, kindly come to page 20 of the trial court's judgment, my lord, fifth line from top. The plea of adverse possession by defendants on ABCD land more than 50 years is also not gaining confidence of the court.
Page 20 of the appellate court judgment, which portion?
Page 20 of the trial court's judgment. My lord, the learned judge in the lower appellate court, my lord, discussing out the page number 20 of the judgment of the trial court. My lord, kindly come to my lord, page 20 of the trial court's judgment. My lord, fifth line from top.
Yes.
Fifth line from top, the sentence starts with the plea of adverse possession. The plea of adverse possession by the defendants on ABCD land more than 50 years is also not gaining confidence of the court as the land is shown vacant in map prepared in the year 1995. If the defendants wanted this court to believe their case, they should have proved their possessed area and ABCD area is the same and identical. The burden of proof was on the defendants to prove this fact and to rebut the presumption arose from the.
Only thing is, mere possession does not mean an adverse possession. Where
Yes.
the appellate court has said that he has acquired title by way of adverse possession.
The appellate court has said that the defendant got no title by adverse possession.
Correct. Then why the suit is dismissed?
Because my lord, the schedule
The area is
not defined. That's why the suit is dismissed.
The appeal shall be admitted on the following substantial question of law. Whether the suit for declaration of
Well,
title and recovery of possession. Yes?
My lord, after the filing of this appeal,
whether a suit for declaration of title and recovery of possession against the defendant
Right.
respondent can be dismissed only on the ground that the description of the property in the schedule does not appear to be the correct description. Question. That's the only
Malad,
question.
one more, Malad. After the filing of this appeal, the defendant number 1 expired. Malad, I have filed an application within time. Malad, the application is scan 2 of 2023. Malad, paragraph 2, we have stated the names of the legal
application for substitution of the heirs and the legal representatives of the deceased respondent number 1 who died intestate on 12/7/2023, leaving behind him full stop, as leaving behind him as disclosed in paragraph 2 thereof. So it appears that the said application is filed within the period of limitation provided therefore. Stop. All the heirs and legal representative of the said deceased are major and sui juris, and therefore legally competent to represent themselves. Since the right to sue survives against the heirs and legal representative, we do not find any ground in refusing to bring them on record. Accordingly, the application being can 2 is hereby allowed. The names of the heirs and legal representatives of the deceased respondent number 1 as disclosed in paragraph 2 be substituted in place and state of the said deceased. The office is directed to make unnecessary amendments in the memorandum of appeal.
I have filed an application for injunction, my lord.
You have not adverse position, nothing. Service 1 week after vacation.
My lord,
You were enjoying any injunction? You were not enjoying any injunction. So
they are
only recovery, main problem is recovery. Their declaration has not been made in their favor. Nothing has been done. So no apprehension. Position is admitted. Position is admitted.
my lord, one more prayer, my lord. The service of notice of appeal may be effected by registered post and the records may be called for by a special messenger at my cost.
Let them come and then in their presence at the time of disposal, do it there.
They have lost the caveat. I have served a copy of it.
Lako. It appears that Lako, this is an application seeking injunction against the defendant respondents. The copy of the said application has been served upon the learned advocate who lodged a caveat on their behalf. Full stop. Since the caveat was lodged when the respondent number 1 was alive, we feel that after the substitution having been effected, the copy of the application should be served upon the defendant respondent, including the substituted respondents. Accordingly, the appellant is directed to serve the
copy of the application was served, my lord, after the death of the respondent, my lord. After the it was served on 30th August.
We fail to understand that unless the substitution is allowed, how can an application for substitution can be served upon the proposed heirs, substituted respondents? We therefore do not take that service to be acceptable, to be legal and acceptable. Any other submission?
Last portion may be deleted. It is not required.
Next.
Well, I am for the petition, my lord. Well, the cost title of the trial court, my lord, the judgment of the cost title and the degree of the cost title, my lord, it doesn't match, my lord.
Judgment of the cost title of the decree of the cost title.
No, my lord. Judgment, my lord. Judgment of the cost title, my lord.
Judgment of the cost title.
Cost title of the judgment, my lord.
There is no cost title of the judgment. The cost title shown in the judgment.
Cost is shown in the judgment.
But it is always in a short manner. It is only in the decree everybody is shown.
But name is not matched, my lord. That's I have corrected, my lord, the order of the register, my lord. From lower court, I have corrected the my lord, degree. Wrong name is recorded, my lord, in decree, my lord.
Section 5, sir.
Yes, my lord.
Section 5.
Section 5, my lord, is not, my lord. 3 days delay, my lord.
So, single bench. It appears that the present second appeal has been filed beyond the period of limitation provided therefore, along with an application for condonation of delay. Since the said application is required to be heard by a single bench before the matter can be listed under Order 41, Rule 11 of the court, let this matter go out of list. Liberty to mention before the appropriate bench. It has to be disposed of by a single bench. We can't. We don't have a power to condone the delay. Next.
But I am the plaintiff appellant. But my client as a plaintiff, it is suit for the judgment of reversal. I filed a suit for eviction.
You got the decree.
I got
and
the
then decree is set aside.
Eviction decree has been set aside.
Eviction suit
Eviction suit.
by you,
Eviction suit.
under what provision?
Suit for eviction of a licensee.
Licensee.
Licensee. Now, my lord,
Why the appellate court reversed?
appellate court is of the opinion that my lord, I became the owner of the property by virtue of a registered deed of gift from my mother.
Can it be gone into if you have inducted?
That is my submission that while considering the eviction
Is
suit,
there any fighting?
there is a
It
finding.
is not a eviction.
Eviction of a licensee.
It's not a
Not
eviction.
eviction of.
It's a recovery of possession from a license.
Now, my lord, the learned lower appellate court, my lord, I lost because learned lower appellate court is of the opinion that by virtue of a registered gift, deed of gift from my mother.
Who granted a license?
But the story.
Who granted a license to you? Yourself.
License. No, I am the owner.
Sorry. Upon revocation of license, you said, then the license.
No, not upon revocation of license.
You said that.
No,
license.
I am the owner by virtue of a registered deed of gift. I permitted the defendant to stay a portion
What
of
is the meaning? That is a license created. You become a licensor. He became a licensor.
I am a yes.
Mr. Mukherjee,
Yes.
you are a civil lawyer. You should know that. I asked you license. Who created a license? So, can a title be gone into?
No.
That's the question I'm asking. Cannot be.
No.
Why the appellate court has gone into?
Appellate.
Simple question. If I have inducted, then 116 is stopping. You can't challenge that I did not have it. Straight away, chotto case. Yes, what is the ground?
It's my ground I have taken, my lord, because learned lower.
We are believing this is what the appellate court has said.
Yes,
That you have failed to establish your title.
No. Yes, kindly see, my lord. Kindly see once. The by virtue of the deed of gift.
I am asking you only.
Absolutely. But kindly see. No,
we
kindly see
are
once.
believing that.
Kindly see once, my lord, appellate court order.
Lago, the appeal shall be heard on the following substantial question of law. Whether a licensee who was permitted to occupy the suit premises by the
internal page
by the licensor can deny the title of the licensor when a suit for recovery of possession upon revocation of license is filed by virtue of section 116 of the Evidence Act. Yes?
No, kindly see once, my lord. Paragraph 20 of the appeal court judgment. Internal page 6, paragraph 20.
This is a longish paragraph.
Yes, my lord. The
which page? At the top, 6 or 7.
Internal page 6, paragraph 20, last paragraph. A careful reading of paragraph 8 of the written statement leaves no doubt that the execution of the deed of gift by the father of the plaintiff was specifically denied by the defendant. The legality and validity of the deed of gift was under challenge in the trial, for which the parties have to lay evidence, and therefore, in the present
What is your relation with the defendant?
Brother.
Oh.
Brother. No, I'm showing that this ground, kindly see. Kindly see.
Yes.
Now, my lord,
hold it, Rakho.
yes. Kindly hold. But section 68 of the Indian Evidence Act does not become operative and functional. In such cases, the document has to be proved in terms of section 68 of the said act. In spite of specific denial of execution of the deed of gift, the plaintiff did not examine attesting witness. This is the only ground. As I have not produced the attesting witness, therefore, deed of gift is not valid. Now, my lord, kindly see, my lord, the donor who has executed the deed of gift, he has not challenged. He has not denied. Moreover, in the suit, my lord, defendant filed counterclaim, ownership by adverse possession, that has been dismissed.
Ownership by adverse possession.
Kindly see the counterclaim.
That shows that he did not claim a rival title.
Kindly see this. Kindly pardon me, I have one copy, my lord. The certificate, kindly pardon me. This is the written statement come counterclaim. দাঁড়া ট্রায়াল কোর্টের এতে আছে Justice Biswa's finance from trial court order, my lord, judgment, my lord, that has been quoted.
Honibhushan Borua is your father.
Yes. During lifetime, father never dispute because my lord, two deed of gift has been executed, one in favor of the daughter, another in favor of the brother. Now, my lord, brother deed of gift, I am not challenging because father has divided the property in favor of two brother and sister. When, my lord, that the brother is in occupation of my property, I filed a suit for eviction. Brother says that I have a title by adverse possession because I am residing there more than 12 years.
দেখো কি বলেছি ওটা দেখো secondly whether the court of appeal below was justified in setting aside the decree passed by the trial court solely on the ground that solely on the ground that the deed of gift was not proved by calling a attesting witness, and therefore calling the attesting witness despite the fact that in the counterclaim filed before the trial court, the defendant respondent claimed title not on the strength of inheritance, but by way of adverse possession.
Attesting witness not required. This is the latest judgment I have brought in respect of the deed of gift. If the donor has not challenged. The original
usual order করে দাও within a week, requisites within a week for effecting service. ওই পারুক না 4 weeks after the reopening. Second appeal, no comparison. Next.
What happened? I'm with Mr. Samanto, but I myself.
What?
I'm with Mr. Samanto, but he allowed me to place the matter.
That's the privilege you are enjoying.
It is my duty because since the Mr. Samanto is here, that is what.
Yes.
But the defendant one is the appellant before the Lordship. It is suit for partition. And the
preliminary or final?
Suit, preliminary.
Preliminary degree, you are challenging or final?
Preliminary degree.
Preliminary degree.
Yes.
Concurrent finding of facts?
Finding of, yes, that is a main, that is a family, deed of family settlement, exhibit
I am
one.
asking you, this concurrent finding of facts? Yes. What is the point?
Exhibit one is a deed of family settlement. In the deed of settlement, original owner, their father already distribute the property.
Yes.
After death of my wife, it will be distributed. Now, what after death of the wife, that is a life interest. The plaintiff, she filed the suit claiming share, 1/3 share. And the court below, ignoring the exhibit one, that the deed of family settlement already that they distribute the property. Well, no, according to section 50 Hindu Succession Act, since the wife has died, entire share to be divided into 3 parts. That is the only issue.
When the deed of settlement was executed?
Deed of settlement was executed, my lord, very recently. That is on 2nd May 2009.
2009. Why
No,
not?
sorry, but that's a wife. 19 November, September 1990.
What about 14(2)?
Yes.
What about section 14(2) of the Hindu Succession Act?
That is back to that, I know, my lord. But
after the Hindu Succession
Succession.
Act came into force,
now either deed,
can you create a life interest? I am just asking.
but no, my submission, deed of that is exhibit one, that was acted upon. If that is acted upon, everything has been mentioned in the deed of settlement. Son, 2 sons, they will get this share. After my death, wife, then daughter also. After death of the mother, as if the entire property now it will be divided 1/3 share. But deed of can ignore the exhibit 1. This is the original owner. He has settled the property.
Settled in what form?
That is my only
I
question.
am asking. A deed of settlement is a mode of transfer.
Yes. Mode of transfer. There is
How? How? Under what concept?
if I am the owner of the entire property,
I am asking you under what? What are the modes that can be done?
but during my life, I have decided the entire property. If there is a dispute to avoid any future dispute after my death, I am now during my.
I am asking you then what the court will do when a deed of settlement comes. How he will construe this document.
According to me, that will be because I have developed.
That will be.
I have developed the property.
That will be. I am just asking. That will be.
I have become absolute owner. My part.
I am again. That will be what?
My submission people the daughter, she has no right. She cannot touch the property. Yes, even if the mother has died. The property was not settled by the mother.
What is to be done in this regard? One has to understand the nature of the document and nature of the disposition. Please. I am coming with a very final question.
Yes.
But I have to, because you are not understanding, though I am making a prelude of it.
Yes.
When a particular document comes before the court,
yes,
executed admittedly by a person, execution is not denied.
Execution is not denied.
Then it is a duty of the court to ascertain the nature of the document. The nomenclature may not be a factor to understand the nature of the document. It may be captioned at something else, but the intention has to be gathered.
Yes. Intention.
So in a case where the original owner retained his right title and interest throughout his life, say, no, I am not divesting. I am executing it, but my right will not go. And then creating a life interest in the name of his wife. And then say that after the death of my wife, definitely me and my wife, it will go like this. Then what according to you, one should understand the nature of the document. What you will style this document as? What?
My submission before Lordship, this is the property. That is why I understood. During my lifetime, I have right title interest. I have divided that will be give effect after my death. The moment he died, automatically the right title will be devolved upon the sons. That is my understanding. And both the courts below.
Suppose a document not styled as a deed of settlement, but captioned as a will, and contained the same wordings that yes, I am the owner, I will enjoy throughout my life.
I
have not. So after my death, my wife will have a life interest, she will enjoy full, and after the death of my wife, it will be distributed. This property will go to this property will go to this son, this daughter, this daughter, this daughter, this daughter. If that being the position, how you will, if though both the documents are coming before you, what you will think that
I have to, if there will, I have to apply for probate of the will. I have to apply. I know on it. I have to apply.
Then what you will do here?
But I receive, I am good.
Then what you will do here? Partition. If the partition and Somebody
For
claims
that
that
reason,
all-
but yes. Now, what happened, man? I have developed the property. I got the second floor.
I do not
Everything.
know. I do not know, but I just wanted to know from you. What is the effect?
But my submission before lordship, in the tricky bullet. But can I go through this only one appeal course finding? He has admitted. But I just see, man.
No, I understand. Then the appellate court has said that no, it is 1/3 because I am putting a question to you.
Yes, your lawsuit is that if there is a will, what you will do? In the will, the property has been, that has been the right that it by how it will be devolved upon the year. You have to apply for probate. If it is objection, will go. It's us. But kindly go through the will.
It will not go. What are you saying?
Suspicious circumstances they prove by
Very
any means
difficult.
practicing for that has been.
It's a registered document.
They have admitted. There's a document is there. Yes, it's admitted.
So once they have admitted that this was
Admitted.
executed, then
They have admitted. Yes,
Then-
the property in this way that has been in this person. Plaintiff also. They admitted. But here the plaintiff must filed a suit for division. Plaintiff he said, plaintiff had got. Kindly see, I am reading only one. Kindly see, the decision which is it, appeal course page 3. Kindly see.
very nice emotional argument, but on the law, please argue.
I understood. According to section 15? No. Yes. The property.
Difficulty is that you have to consider it. One is whether it can be regarded as a gift, which you can't do it under section 122. Whether you can come under the vested right under section 19 of the TP Act or 21 of the TP Act as a contingent right. Interest, that is what a vested interest or a contingent interest, one has to understand. One has to understand in the perspective that what should be the nature of this document. Then in that event, one has to.
That is
This can't be done in this fashion.
my submission is
Your
good case for one. But that is my submission. I can understand because exhibit 1 that has not been. These are the appeal court judgment times. Only guy.
Still you are insisting. Let us go. Then we will decide it. No difficulty. You argue. We have indicated the point. Argue. Yes. What do you say? Appellate court judgment.
Then I have to come again, my lord. But since that question has been arisen before, lost is a good question to me.
Yes. What?
Then I have come. That don't go through the judgment, my lord.
Yes.
I have to give answer, my lord.
Yes.
I have to give you answer. That's from your lost thing, my lord. Then I have to come.
Now what to do?
Intention what was to ওইটা বলতে চাইছে না উইল হতে ওই ওদিকে দিচ্ছে না উইল হতে
তখন এই one তখন
And that suit has been filed by one of the son, plaintiff. But condition has been given that he filed the suit, not the daughter. Not the daughter. Two sons, one daughter.
Daughter is benefited.
Daughter has been benefited.
So why you are challenging it?
Daughter has been benefited.
Then why you are assailing
The
it?
condition has been given. The second floor, he will get that different one.
That will be decided at the time of final decree. Whatever you have made a construction.
Now daughter will come. There is no. He did not get anything. She did not get. Is that exhibit 1? The discernment. He did not get anything.
You are the son.
But son.
And
the
he
fight
is your brother.
Fighting is being. Yes, brother.
Fair enough.
Two son. Daughter is not coming.
She will not come, daughter. Daughter will not.
Daughter
come.
is not coming.
She will not come. You have a good relation with your sister.
No, I have a good relation. Plaintiff. Maybe I do not know. আছে relation বোনের সঙ্গে কারো রিলেশন আছে ভালো নেই that means only before vacation you will say I have now understood what your lawsuit doing. But if you logically admit it is a fit case for my submission matter. Otherwise I shall come with preparation. Now I have understood that was foreign from your law. Now you have understood, I have understood whatever else that is lifted from your. Can you give time? After vacation, not before. কি করবো তাহলে যদি বিচারের পরে ভেবেছিলাম নিজে করে না ডিলিট করে দিত না করে ডিলিট করে দিত আমি জানি
I am for the appellant. I am for the appellant, my lord. There is judgment of affirmance, my lord. And I am, my lord, appellant before your lordship was plaintiff before the learned trial court, my lord. Only, my lord, suit for declaration of title and for permanent injunction, my lord. My lord, I have lost in before both the courts. My lord, what happened, my lord? Learned appellate court held that a joint owner cannot transfer his share. Yes, well, that is the, well, and another point is this, that is tribal people cannot transfer his
to a non-tribal.
No, I am tribal. I am also tribal. For that reason, I am, my lord, pointing out this, my lord.
Did you produce the documents before
Yes,
that
yes,
you are also
yes, that is admitted position. We are, my lord, tribal people.
belonging to the same community or different community?
Santal, both Santal. So there is no dispute that I am not a tribal people. Only the learned trial appellate court held that a tribal people cannot transfer without permission. But there is a rider that he
between them there is no difficulty.
Yes.
Outsider is a problem.
Yes, that is the provision under 14C, my lord.
Where the
My lord, kindly see appellate court's judgment, my lord, internal page 3, my lord. Internal page 3, my lord, of appellate court's judgment. And paragraph
that is a recording of the case, facts, finding. You just tell me.
Yes, my lord, these are all admitted position. It is not disputed.
Please show us the findings.
Yes, my lord, kindly.
Which the decision portion starts from page
my lord 2.
I think page 11.
Page 2 of the appellate court, my lord.
Appellate court, I'm looking
Internal
at the
page 2, my
appellate
lord.
court, I believe. Oh, this is a title suit.
Yes,
Sorry. Appellate court.
Internal page 2, sir.
Page
2 is the decision. Page 2, learned advocate for the, my lord, got it at the bottom. Page 2, internal page 2 of the appellate court's judgment.
Where is the appellate court
Well,
judgment?
it is
I am
not
unable
arranged
to
properly.
find.
It has been given, my lord, after trial court. It is the fault on my part, my lord. My clerk has not arranged properly. It is my fault.
It has to be first.
Yes, that should be first
Page.
internal page 2 of the appellate court
Yes.
judgment.
Show us that portion. Show us.
Portion I am showing, my lord. Page 3, paragraph 3.
I have carefully produced.
Page 3, paragraph 3, my lord.
No,
And
having heard the
last-
counsel on perusal of the record, it appears the suit property originally within the Hasda and such, so that plaintiff did not come with a clean hand. It is not correct that the suit property Hasda and such has no right to sell. Showing her absolute. By this way, that we did not acquire a valid exclusive judgment. The transfer of what is void as no condition is depicted in the suit as per the carefully peruse the judgment. This কি বলতে চাইছে আমি বুঝলাম could not produce that originally. It appears the suit property originally belonged to Hasdas and Kiskus. So plaintiff did not come with a clean hand. Why? Show us 14C.
Yes, my lord.
K.
14C 1D is the, my lord, kindly see 14D 1C. 14C 1D, my lord. That is applicable in our case.
Mode of transfer by a scheduled tribe. You are a scheduled tribe or a
Scheduled tribe.
yes. The transfer is plot or a plot as by sale to the bank. Simple mortgage to the bank. A simple mortgage of the bank belonging to the sale 20%
E. D,
you have sold it or
gifted to be.
See that deed. Whether a property, immune property owned by a person belonging to scheduled tribe cannot be transferred to a person belonging to scheduled tribe, as there has been an embargo created under section 14 within bracket, 14 capital C of the West Bengal Land Reforms Act 1955.
55, sorry, 55.
Whether the finding of the appellate court is sustainable, that without taking permission from an appropriate authority under section 14C, a property belonging to scheduled tribe cannot be transferred to a person belonging to the same tribe, despite the existence of, despite the provisions contained in 14C within bracket 1 within bracket small d of the said act. Service of the application, no injunction now.
My lord, kindly, they are, my lord, disturbing our construction, my lord. I have stated it in my Can 1 application, my lord. My lord,
Sorry.
kindly consider this aspect.
Your deed transfer has been declared void and you are constructing.
That is what
Heard?
they are saying, that I am not the one of the owners, my lord. It is
Sorry.
the observation. I am joint.
Service 1 week after vacation, before the appropriate bench.
Yes.
Before losses.
I have got an administrative meeting at 3:30.
One more.
Wait.
Because tomorrow my lord has.
The Honorable Chief Justice will be waiting for me.
I'm suffering.
No, nothing. Come tomorrow.
Wait.